My name is Don Shang, and I am Chair of Resources. It is September 26th. It is 9:01 a.m. I'm going to go over some meeting protocols before we begin with the agenda items. We're holding this meeting as a hybrid, although all of us are here in person. Awesome. Good to see everybody here. We are all in the boardroom in Honolulu, but we are also holding this meeting remotely via Zoom. In addition, it can be watched live on YouTube. For those testifying via Zoom, we will move you in from the waiting room into the meeting when the board hears the item you signed up to testify on. Please remember to mute your YouTube when you enter the Zoom meeting, or we will get an echo. When you enter the Zoom room, please keep your camera off and microphone muted until the chair calls on you for your testimony. The chat box is not to be used for any comments because that presents a sunshine issue. However, the board secretary may message you via the chat box to ask which item you wish to testify on, so you can be called into the meeting at the appropriate time. Presentations by staff and comments by the applicants are limited to 5 minutes each. We ask members of the public testifying on agenda items to limit their testimony to no more than 2 minutes. Testifiers will not be allowed to relinquish their time to others. I apologize in advance if I ask you to summarize, but we do have a lot of people wanting to testify. I ask if you've submitted your testimony via email, that you stand by your testimony as the board members have reviewed the testimony submitted. Please address your comments to the board and not to the project applicant. To my right is Board Member Smith, who is our timer. He will keep track of the time and give you a 30-second warning. At 2 minutes, I will ask you to stop and he will provide you a sign. I will then move on to the next testifier. Adhering to these guidelines will enable us to, all who would like to present comments, to do so. Before starting your testimony, please clearly state your name and identify yourself for the record. We may take breaks every so often. We will take breaks every so often. I'm now going to read the standard contested case statement. In some of the matters before the board, a person may wish to request a contested case hearing. If such a request is made before the board's decision, then the board will consider the request first before considering the merits of the item before it. A person who wants a contested case may also wait until the board decides the issue, then request a contested case after the decision, but before the close of the board meeting. It is up to you. Any request must also be made in writing within 10 calendar days. If no request for contested case is made, the board will make a decision. The department will treat the decision as final and proceed accordingly. In addition, the board may go into executive session pursuant to Section 92-5A4 of the Hawaii Revised Statutes in order to consult with its attorney on questions and issues pertaining to the board's powers, duties, privileges, immunities, and liabilities. I am now going to take roll call of the board members, and I will start to our left. Board Member Yoon, nice to see you.
Nice to see you, Chair. Aloha Kaiviyan, at large.
Karen Ono, Kauai member.
Denise Seri Matsubara, Oahu.
Alvin Young at large.
Don Shang, Chair of the Board.
Aloha, Riley Smith, Hawaii Island Board Member.
Aloha Mai Kakou, Doreen Canto, Maui Island member.
Excellent. Our acting board secretary today is Ross Miyasato, and our deputy attorney general today is Miranda Steed. We generally hear items in the order unless there's been a request for an item to be moved up. We were able to, as well as I have appropriate staff, division staff available. We will try to make every effort to take those items in the room first. So the agenda has been, we have had a request for a move up. So this is the order of the agenda at this time. We're going to take D2, D3, D1, and then we'll move forward with the rest of the agenda. Item K1 has been withdrawn from the agenda. So thank you. So with that, I'm going to move on to the first item on the agenda, which is approval of the summary minutes, A1, approval of the September 12th, 2025 summary minutes. Board members, do you have any comments, corrections, or edits to the summary minutes?
Chair, move to approve those submitted.
Okay,
Second.
thank you. Before I call for the vote, is there anyone in the boardroom here that wants to make a comment on item A1, the summary minutes of September 12th, 2025? Okay. Seeing none, is there anyone on Zoom, Ross?
No.
Okay, I'm going to close public comments on item A1. A motion has been moved and seconded to approve item A1. Since this is the first vote of the board today, we'll do a roll call. Ross, could you do a roll call vote, please?
Member Yoon. Abstain.
Member Ono,
Aye.
Member Seri Matsubara,
Aye.
Member Young,
Aye.
Chair Chang,
Aye.
Member Smith,
Aye.
Member Conlon.
Aye.
Motion passes with 6 votes.
Chair, for record, I abstain because small kind absent.
Okay,
Yeah.
all right. Thank you for that clarification. We're now going to move on to item D2. And that is Lauren and Andrew.
That's
Request to conduct 2 public hearings on the island of Maui regarding Kahe'ava Wind Power LLC's application for direct lease of state land. Nice to see both of you.
Good
Good
morning.
morning.
Good morning, Chair. Andrew Telio, appearing on behalf of Land Division. Also present with me is Lauren Yasaka, also appearing on behalf of Land Division. As you stated, Chair, this is a request for 2 parts regarding Kahe'ava Wind Power. The first request is to conduct 2 public hearings on the island of Maui for direct lease of state lands to Kahe'ava Wind Power. I think this is fairly straightforward. The rules require us to conduct, they allow the state to lease directly to a renewable energy producer. But one of the requirements is prior to the lease, we are required to conduct 2 public hearings in the county in which the lease is to be had. So we are requesting 2 public hearings on the island of Maui. The second part of this board submittal is a little more nuanced. We're asking the board to make a decision in regards to the scope of the appraisal for the upcoming lease. This isn't as to the lease. This is just solely as to the scope of the appraisal for the lease of Kahe'ava Wind Power. And this came up as an issue because Kahe'ava Wind Power's lease expired. They're on a holdover, and the terms of the holdover, they do require an additional requirement on top of the lease, which is a removal bond. But in the removal bond, it's staff's position that the holdover removal bond was specifically as the removal bond itself, adding that requirement. It's staff's position that didn't remove the board's right or the board's authority to determine what to do with the improvements at the end of the holdover. It's staff's position that the board has the authority pursuant to the general lease to elect to assume ownership of the improvements. So the question at hand for the board is whether or not the appraisal will include bare land or land and improvements. And again, it's staff's position that the board has the authority and the discretion to assume ownership of the improvements. So we are requesting that the board does include the improvements in the appraisal.
Thank you very much, Andrew. Board members, do you have any questions for staff?
Sure.
Yes.
So I'm looking at the recommendations, okay? And
Yes.
so while I understand recommendation 1, 2, 3, 4, 5 has an option.
Yes.
Okay, so can you further explain those options to me? I mean,
So yes, so the first option is option A, which is just to simplify it, it would be no improved. I'm sorry, improved. The second one would be no improvements. And again, this arises because there was a dispute as to which document is controlling. General lease expired. The lease was extended by the board at the December 13th, 2024 hearing. As a part of that extension for the not extension, sorry, the holdover, it was given a holdover. As a part of the holdover, there was an additional requirement for a removal bond. And the board did approve that, but it's staff's position that even though there was an additional requirement added, the board didn't specifically require or approve the removal of its authority to assume the ownership of the improvements at the termination of the holdover. So it's staff's position that if the board so elects, they can assume ownership at the termination of the holdover of the improvements.
Now, Board Member Char was here. Board Member Char has always been very adamant about when we did lease extensions. Should we do the lease or should we just let the lease expire? And then, because then we own the improvements. So I think that has been the board's position consistently, that at the end of the lease, the board owns the improvements, or we can choose to have the lessee or the permittee remove them. So, and I guess that could still be the option too.
That
The
is
lessee
correct.
could decide, the permittee could decide to remove all of the structures, the wind turbines and all of the equipment, and leave it and restore it as it was before the lease, right? So that is a third, but the value of the determination of the appraisal, should we proceed with the lease, is dependent upon one of these two options.
Correct.
And if they choose to remove all of then it would be, and they restart, it would be unimproved land.
Yes, that's correct.
Okay.
So Chair,
Yes.
to be clear in the best interest of the state, which option works for us?
I think we have consistently, at least it's been my experience while we've sat here, we've taken the positions that the improvements are, at the end of the lease, they stay with the state. And the state, so I think especially those leases that we've had in Hilo, where they've come up, and so in those cases, we've agreed to extend a lease, but they put in substantial improvements. So in this case, it's also an opportunity to ensure uninterrupted service. We received a lot of written testimony, a lot of concerns by the community members on Maui that if this was to shut down, then a considerable amount of energy would be lost. And that's why we had agreed to the holdover, the 1-year holdover.
So, sorry, to be clear, of the Paul's comment and question, what is land recommending, A or B?
Land is recommending B,
B, right?
correct.
Okay, thank you.
Wait, you're
No,
recommending?
sorry, A, sorry,
I
A,
was like,
sorry.
wait.
A, yeah, I'm sorry.
Sorry, yes, we're recommending A.
Improvements.
As
Yes,
improved. as
land and
improved,
improvements.
Yes, as improved.
Oh, you guys
Sorry.
okay or what?
Oh, sorry.
Thank you.
Okay,
Sorry.
5A.
Thank you, thank you.
Okay.
Ian left us out here, yeah.
Ian.
Yes, please go ahead,
Um,
Ryan.
After everybody testifies, I'm gonna give maybe a different point of view.
Okay.
So I just want to let you know that.
Yeah.
I have a different point of view regarding the improvements and whether this is a ground lease or not.
No, appreciate that. And I know that the applicant is here as well.
Yes.
Yes.
So, board members, go ahead.
Sorry, Chair. Has there ever been a case where the board has contemplated and or opined, approved or rejected
Oh, thank you.
an appraisal that did not include improvements as and that were considered unimproved lands, 1, and 2, same question, that well, let's just start with that one first. Is there a case where the board has ever contemplated something of this nature?
You know, this is a fairly novel situation.
Yeah, I know.
We're at a point where a lot of our leases are coming to an end. So this will set precedent. I'm not aware of any other cases where we've addressed or the board has addressed a similar situation.
Yeah, we normally don't take the appraisal valuation for things to the board. We're doing so in this case because staff was not comfortable making that decision for you folks. We wanted that to come from you.
Good, thank you. I wanted that on the record. I suspected so, because in the 8 years I've been sitting here, that has never occurred. Secondly, from a sense of community kind of opinion, and maybe you don't have an answer to this, but what is land expecting? What are the expected outcomes of these public hearings? And I
So,
just want to tease this out by saying, if we have the public hearings,
Mhm.
an opinion will be rendered from the public. But in
Correct.
my opinion, this particular case, to what you just said, is more germane to what the board needs to act upon. Because this might fold into the benefits of alternative power, blah, blah, blah. That's fine, but that's not what's being contemplated. That's not the crux of the matter.
so the public hearings that we're holding on Maui are specifically for testimony from the public regarding the lease.
Right.
With their feelings on the lease, similar to how like when they did the HCP one, right? They came before you guys, asked for the public hearings for the HCP. They went and they did it. So the public is primarily speaking towards the HCP. So this one would be sharing their comments and their on how they feel about the lease itself, right? So then we would present that to you in the board submittal if and when that lease should come before you folks for decision making.
Do you think that the community is informed enough and aware enough of the lease and all of its conditions?
I don't know about the conditions part. I believe that they should be, because the HCP process and the lease process are running parallel and they're intersected and kind of intertwined. It's out there. It
Uh-huh.
is in the HCP. I have been monitoring DOFA's side of everything. So yes, the lease has been out there. The HCP meeting did not get as much public attention as I think perhaps you folks may have wanted. However, are you asking us to do more?
No, no.
Okay.
My concern is the level at which one understands and is cognizant about the terms and conditions within the lease is probably very rare.
Mm-hmm.
I may be dead wrong, but I mean, I've read it twice and I still have to read it and read it and read it, right? So I just don't want this to devolve into something that it's not. I mean, it's correct. They're there to opine on the lease,
Mm-hmm.
but there are other fundamental issues here that might slip through the cracks.
Correct. You're not
Which is
wrong.
my concern.
Yeah, I think it's just more so, being very clear when we go out to these public hearings, what the purpose of the hearing is for, and really trying to put those guardrails up in terms of what type of testimony is offered. However, it is public testimony. We cannot necessarily stop them from sharing whatever they want to share. And, I think it'll show in the board submittal how we summarize that testimony for you folks. We'll try to consolidate all the information as it pertains to the lease, while also mentioning there may have been other concerns shared.
Okay, thank you.
Yeah.
Fair enough. Thank you, Chair.
I think the purpose of the public hearing is more about the project itself.
Correct.
The terms of the lease, they're statutory.
Mhm.
It is what it is. We have to charge, appraised value. So there are certain terms and conditions, and that's the kuleana of the board. But I think it's the intention of the public hearing is really to gauge the community's comments on, especially since this is going to be the same provider on a new lease. How have they performed? What has been the impacts in particular on species? We've received a lot of favorable comments about the benefits of renewable energy. But as you say, board member, our kuleana is a little different, but we always have to kind of balance this dual public interest, renewable energy and protection of the resources. And that's why I think the department, to the benefit of Land Division, OCCL, and the AG's office worked very hard to ensure there was uninterrupted service over this, because the lease terminated last year, but we were agreeing to do the holdover. The board approved that. Thank you for the
Thanks, sir.
question. So any other questions, board members?
I have one.
Yes, go ahead.
Is there a possibility of separating the recommendations, like 1 through 4 seem to be all related to the public hearings, and then 5 comes out to the appraisal?
Well, I think they need direction because before we can enter into a lease, we need the appraisal to be completed. So are you suggesting you want more time?
No, I just think that there's 2 responsibilities here, like you guys mentioned. The public is the upper portion of the recommendation, the public hearings. Then when you come down to 5, that's more on the board side on what we want to do as far as the appraisal goes.
But I think all of the all of the recommendations are things that only the board can authorize. Is the holding of a public hearing, it's, these different conditions. So I think they're within the responsibility of the board to decide these.
I think that's what I'm looking at. This is, there might be some kind of discrepancy between, especially 5A and B. And that might just turn the whole thing over, which is not what we want to do.
So the other concern is time is of the essence.
So
Their
I,
lease expires in January 2026. This does, and the board, that means that the board has to approve the lease. We're trying to get it on the board agenda in December. It does mean that we will probably have to go to Maui for this board meeting in December. The latest we can do it is the first meeting in January, which, because if this lease, if it expires, they turn it off. They're not allowed to use it. So we're trying really hard to ensure uninterrupted service but recognizing the board has the responsibility to decide, one, whether they get a new lease or not. So I think these are, my preference is that we handle these all as one, because they're all within, it's directions that the staff need to move forward on this. So that's,
If I may, Chair, Member Ono, just to address your concerns, typically the appraisal comes after the lease is approved. At the applicant's request, we have brought this. They do, I understand, have to make a decision. And their decision will be based upon what the appraised value is. So we are taking this slightly out of order at the applicant's request.
Thank you for explaining that.
any other questions, board members? I know the applicant.
Just a quick
yeah,
comment.
go
I
ahead.
just want to commend both of you without Ian. Great job. Thank you.
Thank you.
We
We
miss
have
him.
very good.
But they're not done yet, Paul.
But you
The
know,
day is early.
he was the godfather here, so.
Yeah.
Oh.
I'll have to share that with him when he comes back.
That with the- please share that.
Thank you.
Okay, so I'm gonna now take the applicant. And then I'll open it up after that for public comment. So, yes, Judy, David.
Sorry, it's warm because lots of bodies, but the AC is working.
It's very comfortable.
Okay.
Yeah,
Cool.
yeah,
Yes, if you can introduce yourself. and then
sure, of course. Yeah, aloha chair. My name is David Purcell. I represent Kahaiva Wind. I did prepare some brief remarks. I'll say I welcome questions. I know there's a lot of topics, and so I welcome the questions, and, please feel free. Also like to thank, of course, Lauren and Andrew for their comments and, their support as we're bringing this application before the board. So if you'll oblige, I just prepared some initial remarks. Of course, I appreciate the opportunity to come before the board again today. First, I wanted to address, I want to apologize that KWP was not present at the August 22nd board meeting. It did conflict with, so that was with regard to, DOFA's request for an HCP hearing. It did conflict with an ESRC meeting, and, there was a misunderstanding, I think, on our part about the scope of that discussion. So I wanted to apologize for that, and I also wanted to be clear that KWP will be represented at any future meetings that involve the wind farm. I just also want to, mention too, that I'm joined by several members of our team. So Jody is our local counsel here sitting with me, Dean as well on Zoom. And then I'd also like to make mention of our staff biologist, Molly Stevenson, who's sitting over here, fresh out of the field this week, working on Molokai with our new Nene pen, which we're proud to say, after starting that last summer in partnership with DOFA, has been successfully established and, now is supporting roughly 30 birds, which is, a significant increase from just the couple of breeding pairs, I think, that were left on Molokai. And we're really excited to see that progress continue. I also want to address, because it came up at August 22nd, I want to assure the board that we take our mitigation obligations very seriously. We have completed our obligations for all species except for the Nene to date. I want to address one item regarding the Nene. So we do have two irrevocable standby letters of credit totaling approximately $3.5 million with the BLNR as the beneficiary currently. And, that's in accordance with how the HCP was originally drafted. But I'd further like to assure the board that we're continuing to discuss that matter with DOFA to make sure the state has all the assurances that it requires that KWB will complete its mitigation obligations for the Nene. And lastly, before turning to the agenda, I just also wanted to update the board that we had a good few public events last week and recent weeks. So one, of course, DOFA had requested approval and they conducted their HCP public hearing in Wailuku. And in addition, the ESRC and, in partnership with us, we held a broad open house. We brought members of the public up the wind farm where we were there to answer questions, tour the facility, and also get to meet, our full-time local Maui employees who work there at the facility. With regard to the matters in the agenda, first, on the first matter, of course, we just want to emphasize our support for Land Division's recommendation to hold two public meetings on Maui. And, like those before, we believe it'll provide further transparency, presenting information about KWP's lease request and allowing for community, and stakeholder input. We've had several meetings to date, and I think we've received really good feedback from the community, and we think Land Division will have the same reception. And then I'll turn to the other matter on appraisal. So, we've been engaged with DLNR staff for a couple of years on the new KWP lease, and we understand, the board's been asked now to determine the scope of the appraisal and therefore the future rent payments and whether they should be based on, raw unimproved land or the value of land plus improvements. And, we did submit a written testimony and I'll touch on a few of those pieces. I'll say it's our strong recommendation to the board that they declare KWP's appraisal will be based on the value of unimproved land only. And as it's been for the past 20 years, and it's really for several, what I believe are very deeply practical reasons. And if you'll oblige, I'd just like to share a couple of those. So first, principally, KWP is a renewable power plant. It's a power plant on Maui. To continue the operation of that power plant for another 20 years, we're planning to invest in major maintenance in that facility, as would be customary at any type of power plant. In order to do that, as a standard matter of industry practice, KWP has to raise third-party debt financing. And that financing is ultimately secured by the assets of KWP. And that's not unique to this project, that's standard industry practice. And to be clear, it won't be possible to secure such financing at the conclusion of the holdover term, if the improvements revert to the state and KWP simply does not own them and is merely renting from the state. That outcome will prevent us from delivering on our proposal to Hawaiian Electric and Maui from reaping the benefits of a low-cost power plant that would be, we'd be able to invest in and would continue for many more years of safe operation. And a few other matters, if I may. So secondly, I would like to mention the importance of energy affordability, given that the rent that's paid by the facility is directly passed to Maui consumers and Maui ratepayers. Now, while we can't reopen our pricing proposal to Maui Electric, which was made in 2023, even if we could, if the rent increased on KWP would simply be required to pass that rent on to consumers, along with a higher cost of capital due to the inability to secure financing if we don't own the improvements, and a likely loss of federal tax credits due to further project delay. That would simply increase the cost to Maui consumers, and we believe is directly in conflict with the state's public policy objectives, including improving energy affordability and addressing the very high cost of living in the state. As you know, Maui and Hawaii residents face among the highest electricity costs in the United States. Relative to fossil fuels, KWP saves customers millions per year on Maui. Right now, it's about 7 million per year based on the slightly lower price of oil this year. Last year, it was around $10 million. And it delivers this energy at a fixed price, and it's committed by the structure that Hawaiian Electric has set forth. It'll be a fixed price for the next 20 years, which promotes bill stability and predictability. Third, I think I'd also like to mention that we believe the board should consider the impact to all public trust lands where KWP's output to be immediately replaced with a fossil fuel resource. I think climate change and the impact on the environment is beyond the scope of my testimony today, but energy from KWP would need to be replaced in the immediate term by burning more fossil fuels from an aging fossil fuel generation facility on Maui. And we believe it should be unambiguous that this will have a greater impact on the environment. Fourth, I'd also like to just take mention of the environment that we're operating in now, where there's significant uncertainty for renewable energy projects, both in the state of Hawaii, but also on the mainland as well. And we believe there's an extremely limited window now to preserve a low-cost power plant for Maui. You may be aware, but following the passage of the One Big Beautiful Bill, renewable energy projects face a very narrow path to qualify for longstanding renewable tax credits. So KWP's 2023 pricing proposal to Maui Electric includes the benefits of those tax credits. They're there, right, for Maui. And, were we to not go forward with this project, if we're able to bring any other future projects or proposals, it's likely that we would not be able to qualify for those, and Maui would not be able to benefit from federal tax credits, given the change in legislation. And lastly, I won't spend much time on it. Our counsel is available to discuss it. As a legal matter, we do believe that the controlling language of the KWP lease agreement with the state requires that the board not assume ownership of the KWP improvements and equipment, and that the board appraise based on unimproved land, because the original lease was modified by the holdover to create a controlling removal obligation on KWP. And of course, that's a legal matter that our counsel will be happy to discuss. But I appreciate you. I'm sure this went more than 5 minutes. Thank you for the opportunity. Aloha, and I'm happy to take any questions.
Thank you very much, David. Board members, you have questions for David?
Sure, I do.
Yeah.
Thank you for that. To your second point, what percentage of the hike to the consumer are we talking about?
On if KWP went away. So right now, part of the issue is that avoided cost of electricity is set by fossil fuel. So people's bills vary. And as oil prices come down a little bit, KWP saves about $7 million a year across all ratepayers. And last year was about $10 million. If oil goes up, that number will be higher. If oil comes down, that number will be a little bit lower. And, if KWP went away, that would just immediately be an additional cost to ratepayers on Maui.
To us. Okay. Yeah.
Any other questions, Paul? Riley?
No.
Is that a couple questions? So, on your statements about the August 22nd meeting and the HCP, so you're stating that KWP is in compliance?
I don't believe that's necessarily our position. We're, fulfilling our mitigation obligations, I think. Or, I'm sorry, our judgment to make. I know others have commented on that. So I think, we're complying and trying to fulfill our remaining obligation on the NA, yes.
That's a yes.
Yes.
Okay, cool. Because at that meeting, there wasn't anybody from your organization, so it was unclear whether you guys were in compliance or not, or on the trend to be in compliance.
Yes.
So I just wanted to confirm that.
Yes, yes, we believe we are, yes.
I know there's some statements made earlier, but I just wanted to understand. So is it your position that your tenure on this property is that you have a ground lease?
Correct.
Okay. And you've continuously had control over that ground lease. You've provided power to Hawaiian Electric, which is then goes to the consumers on Maui
Correct.
continuously. So even during this holdover period, you've continued to operate the facility. There's been no change in ownership on Kahiava. So it's the same tenant on the same state property, utilizing the improvements that you built. Okay. The intent is that you would continue to own and operate the improvements that you built until you terminate the lease. And then at that time, the improvements would revert to the state. If the lease ends, there's a removal bond that you're going to be required, or you are required to comply with. That if the state decides that they do not want the improvements to remain, you are agreeing to be obligated to remove those improvements.
Correct. That's correct. Yes.
And at that same time period, should the lease terminate, if the state decides to retain ownership to those improvements, at that time, the improvements would revert to the state, but not now.
Maybe
Yeah.
we can jump in here and
Or I mean,
Perhaps I can answer,
is that-
address that question. Board Member Smith, this is Dean Yamamoto here, outside counsel for KWP. I think I want to understand the question. Your question is during the existing term and under the term of a new lease?
I guess what I'm trying to clarify is that during the original lease, it's a ground lease, you built the improvements, you own and operate and maintain the improvements. During the holdover, you continue to operate and maintain the improvements that you built. When the new lease is executed, assuming it is, and you operate the wind farm, you're going to continue to own and operate and maintain and invest in capital expenditures to improve the capacity or the capability of the wind farm to continue generating power. Continuous ownership throughout, right?
That's correct.
Yes,
I just wanted to confirm that.
yes.
Okay.
Yep. Apologies for misunderstanding your
No.
question,
Yeah,
but thank you, yeah.
And I think part of it also is, the question of whether or not the state still has the right to basically, or the option to take over the improvements after the expiration of the lease. So our position, as we set forth in our testimony, is that the language of Section 11 in the original lease, which talked about the fact that the state could exercise that reversion right, that was replaced and superseded by Section 4 of the holdover, which basically said, no, you need to remove everything with no depth limitation, and we're going to ask you to do a $15 million bond to secure your removal obligations. So in other words, you no longer have the option for the reversion because those two things are in conflict. And in Section 4 of the holdover, it talks about, if there is a conflict, that the holdover prevails. So that is our position. And we understand, Chair, what you were saying about how your general position has been to have the improvements revert back to the state. We understand that. And in that one example that was included in the staff's recommendation, it talked about a particular lease. But what we would say is that that particular lease had language that specifically said that the improvements at the end of the term of the lease would revert to the state. So then that's clear, right? That's in the contract, that's in the lease. What we would say is ours is different, right? Because we had a lease, right, that had this potential reversion right, but then the holdover superseded that by saying you need to remove everything with no depth limitation, and you need to provide a $15 million bond in order to secure that absolute obligation to remove. So that's our position, yes.
And if I can make a comment, so what I was trying to clarify was the difference between some of the Kaneohe leases that have occurred in Hilo, where there was a change in ownership. So technically what happened is there was a ground lease, a tenant built improvements, and then the lease terminated. And then a successor organization took over. And at that time, then it was no longer a ground lease. It was the ground lease with the improvements built on it. In this situation, you guys have continuously owned and operated and maintained it. You're planning to put in additional capital expenditures to improve the efficiency and operation of your system. So there isn't that change in ownership
That's
or
right.
term where the land and the improvements reverted back to the state. You guys have been in control the entire time. So that was the point I was trying to
Yeah,
make.
that's exactly right.
Okay, thank you.
Thank you. Board members, any other questions?
Yeah, okay, so did you concur with the terms and conditions of the holdover?
Did we concur with them?
You can,
Yeah, I mean, we executed it. Yeah, I think that,
executed it.
yeah.
but you just said. Can you repeat your last sentence? I forgot your name. I
Jody, I'm sorry, Jody,
Jody,
yes.
I'm pointing with my pen rudely,
It's
Jody.
okay.
Can you please repeat the last two sentences of what you said?
My last sentence.
Because it's incongruous with if you concurred and executed with the terms and conditions of the holdover, in my mind.
Okay, all I'm saying is that the original lease, Section 11,
Right.
basically said that you guys had the option to have the improvements revert back
Correct.
to you. But then we executed the holdover, and the holdover, Section 4, I believe,
Right.
basically states that
we need to, KWP at the end of the term, we need to remove everything with no depth limitation. And we're securing that removal with a $15 million bond. In other words, you know what? You gotta remove the stuff.
Right.
Right? And our argument is that there is no option for the state now to basically have the improvements come to the state. Because those two things are incongruous, right? You cannot have the option for the state to retain the improvements and say, hey, you guys got to remove your stuff and we've got a $15 million
But at the
bond.
time that you executed the holdover, did you have the same sentiment of what you just said?
Sure, yes, yes.
And why execute the holdover?
If I could add,
Yeah.
excuse me, this is Dean Yamamoto. Could I elaborate on that?
Go ahead.
Yeah, so the way the two documents work is, section 11 of the lease talks about end of term of the lease. What happens at the end of the term and the lessee's obligations at the end of the term. And it says, at the end of the term, there are these removal obligations, but they're candidly fairly light. And then it goes on in an additional clause to say the lessor, DLNR, has the option to assume ownership. Section 4 of the holdover says the holdover effectively amends the original lease, and it replaces the provisions relating to the end of term in the original lease. And then it goes on to say at the expiration or the earlier termination of the holdover, lessee shall remove, it shall not be subject to a depth limitation of foundation removal. It additionally needs to provide a bond to secure the obligation. And then it goes on to say that in the event of a conflict between the holdover document and the original lease, the holdover document controls. It's inconsistent for the lessee to turn over ownership of the improvements when it has an absolute obligation to remove those improvements.
Yeah, I understand, Dean. I understand.
Yeah.
My question is, whatever the conditions are, wherever the chips lie in favor of the state or not, put that aside. Did you contemplate the conditions of the holdover? And I agree with you, the conditions of the holdover amends the lease. I agree. At that time, though, why execute if you're comfortable with the terms and conditions of the lease, knowing that the holdover would amend the lease?
If I can, the lease expired. So for them to have,
Yeah, I got it.
so
I got it.
the only way that,
But my question is, okay, the lease expires tomorrow.
no, the
You're
lease
sitting there-
expired 1 year ago. The lease expired in 2025. For them to continue uninterrupted service, the board agreed to give them a holdover.
Right?
The lease, if you look at your attachments, the lease document, which is Exhibit C, is approximately 27 pages. And it has attachments. The holdover.
Yeah, I've read it, Chair. I've read it.
Okay, if you look at the board submittal, the board had the option, because this is an old lease, it didn't include the removal bond.
Got it,
That's my recollection of what the discussion was,
got it.
is in order to have parity and equity with all of the leases, the modern day leases, that this was our opportunity to require the holdover, to require a bond, a removal bond, because maybe they weren't going to get the lease. Maybe they couldn't get the PPA, maybe they couldn't complete the 343. So that was why the removal bond was required, because if today, if they didn't complete their 343, they would have to remove everything on the site.
Yeah, I get it. The necessity of the holdover is not what I'm questioning. I'm questioning the moment that you've read the terms and conditions, why execute if you had an issue with it, regardless of, because I'm not to be thick, but I'm confused to what Jody said and how. Go ahead.
Let me address that. We're not saying we're not comfortable with the holdover terms. We're saying that we are comfortable with the holdover terms and that the holdover document governs the relationship at this point relating to end of term. And what we're saying is that the language in the original lease no longer is applicable because it was replaced by the holdover language, which we accept, which was drafted by DLNR, which we accepted, and without negotiation, quite candidly, we didn't provide, ask to make any changes to the document, and we accepted them. So what we're saying is, yes, we are, comfortable with the holdover document.
So I think, board member, we disagree. We have a legal disagreement. So they believe that the holdover modified the lease. We, DLNR and our legal counsel, do not believe that. We believe the lease still applies. The holdover permitted them to continue, but under the terms of the lease, the improvements at the expiration of the lease go back to the landowner, which is the state. The holdover only permitted them to continue the additional year. So that's a disagreement. So that is their interpretation.
So I one more time. At the moment that we all sat in the room and we all signed this document,
Yes.
why didn't we have that discussion then? Why are we having it now, is my question. Why does the board have to opine on it now? It should have been handled at the point of that execution.
Because we have lawyers who have a disagreement.
Lawyers always fall back on that. Look at Danica smiling at me.
I mean, it's the interpretation, but that is our position here. I mean,
Ugh.
all of our positions have been at the term. So let me ask you, David, when you did debt financing for the original Paheava 1, did you at that point in time contemplate the payment that you included the cost of all of the improvements?
So of course, I didn't personally raise that facility, but
Okay.
that would have been raised at the time to finance the improvements, yes.
So the cost of the improvements have been amortized and they've been paid for. Isn't that correct?
Well, there's a substantial incremental investment, a very substantial incremental investment that needs to be made in the facility to recondition it to serve the next 20 years.
So,
And that's the key distinction, I think, because the plan as itself requires that investment to continue. Sorry.
so your investment would be even more substantial if we required you to remove all the turbines, which we have the option under the holdover. So under the holdover, if this legal disagreement is, okay, at the end of the holdover, the state, you don't own the improvements, we can ask you in the next 2 months, remove all your improvements. Isn't that an option that the board has?
Yes, but that I just would submit that investment to remove the equipment is smaller than the
But that's the
investment that we
$15
plan to
million
make.
that you put up in the bond. Because that was the estimate you gave us to remove it.
Correct.
So we also have a public trust duty, right? You have amortized the cost of the improvements that are already there. Moving forward, that's another debt financing that you will take and you will pay, and the ratepayers are going to pay that over the next course of whatever your PPA is, 20 years. So the notion that this in some way if we appraise it at an improved value, the ratepayers are going to pay more money. The ratepayers are going to pay more money because you're going to put these substantial improvements on, but it's not ownership of the improvements is separate and apart from what you're going to charge the ratepayers.
Maybe I could just add one clarification. So, the nature of the work that we're doing, we have a wind turbine and it has internals, right? And what we're going to do is effectively replace those internals, okay? And that's very expensive, requires, raising this additional facility. The entirety of that completed turbine after we've made that investment, that is what secures, and the ability of that turbine to operate for the next 20 years, that's what actually secures the financing. if we didn't own the turbine, we wouldn't be able to secure the financing. We wouldn't be able to raise the new financing. We wouldn't be able to make the investment. So the proposal to continue the life of this wind farm and make a new investment requires us to have.
But that was based upon a presumption that the board would grant you a new lease.
I don't want to say we would presume the board done.
That's the only way that you would have kept the turbines.
What I would say is, as a matter of standard industry practice, if we don't maintain title to the equipment, we can't raise financing. That's just as a matter of standard practice. So taking our unique circumstances to the facility.
It's a real difficult quandary to put the land board in balancing competing public interests, renewable energy, and we have received a tremendous amount of testimony and support of what you're doing, no doubt about that. But we also have a public trust obligation. And these are public lands, and we're giving you somewhat of a discount. And I mean, to the extent that if you're going to say that you own the improvements. But this is going to set precedent because we have got a lot of other wind farms or renewable energy projects that's leases are about to expire. So how we treat Kahiava here will dictate how we address all of the other renewable energy, or just actually all of our leases. So, I mean, I think that's why this is kind of a critical decision for this board. In my mind, it is a policy decision, whether we're now going to say that the improvements at the expiration of the lease, they remain with, it's almost your option. You can either, if you don't get a lease, then you're going to remove it or you could leave it. But we as a lessor, the owner of the land, we're put in a position based upon your interpretation where we're giving up that right to you as a lessee. And to me, that's an issue that I have with our public trust duties. Just board members, any other
Out of
questions?
Curiosity, would any of this rise to this level if there was indeed, well, let me start with this. Would you agree that there's a decrease in appetite for renewable energy tax credit with this federal administration? Yes or no?
I mean, I can't speak for the administration, but the new policy, right, has changed, right? So now, most new projects that come online, they just won't be eligible anymore.
Yeah.
Yeah.
Is this one of them?
This project, if we can meet our timeline, will be eligible. And we do assume full eligibility in our pricing. So I would say, yes, this is one of.
So isn't that a significant contributing factor in this discussion?
It is.
It is, right?
Yes.
I would have led with that. Because I don't think you caught, even if, okay, let's say the tax credits were in place, like no change. Would we be having this conversation to this level at the board level?
I think it just increases the, unfortunately limited amount of time we
The tax credits
have.
could be huge, right? I mean, if the tax credits go away,
Yeah.
your financing falls apart.
It just becomes a much more expensive facility for Maui, which we don't want.
Yeah. Which you pass on to the end user eventually, right? But it obfuscates things, right? Yeah. So I'm just out of curiosity, are we going through this gymnastics because of that?
I would say,
Because
Yeah.
David, to say that it's you want the appraisal based on unimproved land is crazy to me. Right? I mean, I don't see the logic or justification how you can support that.
I think it's the state ownership. It's the idea of it reverting to the state. And if we don't have ownership of the improvements, all of the improvements, we can't secure financing against it. And we can't invest in the facility and we can't deliver on our
You knew that
proposal.
going in, right?
I think I use the same response that I gave to Dawn. I understand we're in a unique situation, but just a normal renewable energy facility, which, we do, others do, power plants, it's just standard practice that financing counterparties have to have an interest in that facility in order to actually lend against it because they need to know that it can continue on.
Yep.
Right.
Okay, all right,
Yeah.
thank you.
Yeah.
Thank you, Chair.
Board members, any other questions for the applicant before we take public comments? No, I appreciate that. Oh, go
I
ahead.
just want to
Ryan.
make one comment.
Yeah.
So there are federal uncertainties with future energy credits and incentives. We have an operating wind farm. We have a willing operator who wants to continue to serve and minimize future increases to the residents of Maui. Because when you sign a purchase power agreement with Hawaiian Electric, it's at a fixed price per kilowatt hour. And if that is less than the avoided cost with fossil fuels, the residents of Maui benefit.
Right.
So if you are not, or if you're unable to continue operating in January, the residents of Maui will lose the benefit of you operating there. Is
That's
that an
correct.
accurate statement?
That's accurate. And it's not just from us. We've had HSCO here before who's validated, what we've said about that avoided cost differential. I can't speak for them, but I know they've shared that comment in the past.
I don't
Yeah.
dispute that. I
Yeah.
mean, and we've tried everything we can to keep moving in this direction.
And
But yeah, this is somewhat of in my view, it is a policy issue. It has broad implications to DLNR as a private, as a landowner of public ceded lands.
And if I may,
Yes.
I would just say that from a legal perspective, we believe there's a path forward. And again, it's that argument that the holdover conflicts with the original terms of the lease and that reversionary option. And so because of that, it doesn't exist anymore. And we're moving forward with, basically having to remove, assuming we don't get another lease, right? That's what we're all hoping for, is that we're able to, enter into another long-term lease.
which
So
maybe
that's
would be
not-
different in other
Right.
future
That's right.
circumstances, right?
And then the other thing, Chair, you're talking about the precedent.
Mhm.
What I would say is, there are ways to kind of address that, maybe through your leases, right? So to include specific language with respect to your reversionary right. Like for instance, in the sample lease that was noted by staff, right? You guys had the language right up there, right? So it was clear that at the end, the improvements reverted to you. So you can still control that via contract, right?
So our
So,
current leases do have that language that
Yeah.
they revert. So our language is clear. I think it is I think a difference of legal opinion, of interpretation. I mean, at least when I sat here as a board member on the holdover, it was never my intention to supersede the lease. The lease has, if we take that position, the lease has all kinds of provisions related to access, related to, we got issues related to repairs, to liens, the
Just
character
that
of
one
use.
provision.
Yeah, it's
Yeah.
just the one,
But
and it's only if it's a conflict. Yeah.
But that holdover was to benefit you. It wasn't to benefit the state, because the lease would have automatically terminated by operation, by its term.
Sure.
But because you needed more time to do the 343, to comply with the HCP, to negotiate with HECO, we did everything in our powers to make sure that we found it, and it was the holdover. But I also think it was very clear, at least in my mind, by the board members that were present, that the holdover was not intended to supersede the terms of the lease. It was just to provide with respect to the removal bond, because the original lease did not include a removal bond, you could actually just walk away. And we wouldn't have been able to, you could just leave all the Apollo, and we do have, if you go down to Upolo Point, there are wind turbines there that are fixtures, and nobody's moving them off. So for us, South Point, South.
South
So,
Point.
I'm sorry, I don't need to go on and on this, but I think, so there is a disagreement on, I think, our legal interpretation, but I also think this is a policy decision by the board,
Yeah.
far much greater than just legal.
Understood.
Chair, may I say something?
Yes, go ahead.
So I think, respectfully, I disagree with the characterization of the holdover document. Because I think if the point of if the holdover document was intended as presented to us, the drafted by DLNR and as presented to KWP was solely to add the bond, it would have been one paragraph long. It wouldn't have addressed it wouldn't have restated in its entirety the end of term requirements and obligations of the lessee, which is what it did. So I think respectfully, we disagree with, that characterization of what the legal effect of the holdover document is. But also, I would say, I think it's important to take a step back and think about why lessors, commercial lessors in particular, generally have a reversion provision in the lease. And it's because the lessor believes that they're going to have some asset that has value to that lessor following the end of the term that it can pass on to another lessee. In this instance, this is not an office building. This is not a hotel. This is not a warehouse. This is, a bunch of complex operating machinery that, requires sophisticated operators to operate, and it delivers a product to, essentially one buyer, which is the utility. That one buyer only makes available an opportunity to sell to it once every several years. So I would say that the nature of this improvement is really, really unique. And it's not like the other types of, improvements that that typically come before the board. Similarly, I'd say, the solar projects that were referenced also, I think were, fall into the same category. If the state assumed ownership, there would really be no other lessee to take it unless that lessee had a PPA. And the opportunities to get a PPA come around only, once every handful of years when the utility and the PUC decide that it's appropriate to issue an RFP for a new PPA.
And I appreciate that, Mr. Yamamoto. I do think similar arguments are made by many of our tenants. So as a result, we have statutory authority to amend the lease, to extend the lease, so long as they put in substantial improvements. Then it gives them enough, but we don't have that liberty in a renewable energy project. You have a lease term that's kind of tied to your PPA. So we can extend a 65-year lease if they put in substantial improvements. So that is one way that there's some assurance they get to stay on the land. But like I said, I mean, I think this is a policy question. I appreciate the arguments made by the applicant, and this board will ultimately they may or may not agree with the state's interpretation. They may feel differently, but I think we'll leave it at that.
One question.
Yeah.
So, Mr. Yamamoto, you just mentioned that you disagree with the holdover document.
No, I'm
Why is
sorry.
it
I
being-
said I
Oh, no.
disagree with the characterization that the holdover document simply added a bond requirement. What the holdover document did was it fundamentally changed the end of term obligations of the lessee. So of KWP. So the end of term, it substantially modified it. It increased a number of the obligations of the lessee at the end of the term. That's what I said. So I'm sorry if I wasn't clear on that.
Okay. Thank you, sir.
Okay. Thank you very much, and appreciate the advocacy. Okay, with that being said, I'm going to now open it up for any public comments. Is there anybody, no one has signed up for D2. Is there anybody? Yeah, David.
Thank you, Chair.
Thank you. Thank you for being here.
I know very little about this issue. But I want to propose, there's a very easy solution. all you folks are doing is determining how the appraisal is going to go. You are not deciding, you cannot decide today that you own the improvements, but you can assume you own them for the appraisal. They can continue to assume they own them and get their financing. The only issue is how much money you're going to be charging them. This is a smokescreen issue they're raising to not pay a lot of money. That's all it is. They can continue to think and argue to their financiers that they own it. All you're doing is saying, this is the basis upon which we're appraising the property. That's it. Thank you.
Fair enough. Thank you so much, Dave. Is there anybody else in the room that'd like to provide us a comment? Yes.
Hello, I'm not familiar with this, but just listening. My name is Kate Thompson and I'm here for a different item, but I would think that some kind of balloon payment to basically say, I'm going to buy my old car and I'm going to fix it up. And then we'll set a price for what that old car costs before I fix it up. Thank you.
Is there anybody else in?
Oh, man.
See what happens when you
Downey
don't.
So what happens
Downey.
when you guys go so long.
Yeah.
Hello, Chair, Board,
Nice to see
Keone
you.
Downing.
Yes.
I'm kind of along the line of Board Member Smith in that they took this land over unimproved. Okay, this is a renewal.
No, it's not a renewal. It's a new lease.
It's a new lease.
It's not a renewal.
So they're taking over this land now in the new lease. And in the new lease, you're deciding if you're going to charge them improvements
Right.
versus
Unimproved.
unimproved lands.
Right.
It's the same group of people. They've been doing good for Maui.
Don't dispute that.
Okay.
Yes.
By listing, you force them into a bond to remove it if they do not get the lease, or they have the option to either remove it or leave it to you,
We have the option.
or you have the
We have
option.
the option.
So you're gonna have qualified people to inspect these turbines that you hope have some benefit to you. And if not, you're gonna use their bond to remove it, correct?
Or they will be required to remove it using their bond. Yes.
Using their
Yes,
bond.
Yes, yes.
In the term, then you go back to unimproved land with no person creating electricity for Maui. It's like, are we looking to take care of, say, I understand that you're looking at all these pieces down the road, but I got 30 seconds. So I'm sure you'll make the right decision,
Thank you.
but I believe it should stay unencumbered,
Okay, unimproved land.
unimproved land.
Oh,
Thank you.
I appreciate that, Keone. Thank you. Anybody else in the room wants to provide it? Okay, I'm going to go into Zoom. Is there anyone on Zoom? Okay. All right, board members, I'm going to close public comments. Is there a motion? Is there discussion? What's your pleasure? Go ahead,
Question
Deb.
for staff.
Yes, okay. Lauren, Andrew?
Sent you folks an email yesterday that kind of recited all the different things I said about ground lease versus improvements. Did you guys have any counter points of view or any clarifications? And what I tried to include in that was the distinction with the Yamada transfer, where they had agreed to assuming the improvements in the renewed lease. And so I thought that GL that you guys had referenced was slightly different. So I had just given you guys the opportunity if you wanted to raise any questions.
I just kind of think that we just want to remind the board, right, why we're in the position we are in today. They had the option to extend the lease. They did not make it in time. That is why the holdover was executed. And that is why we are here today with this particular decision in front of you. You know, I think Chair has summed up kind of where staff's brain is on this. You know, it's a precedent. We have to be very mindful of how we proceed forward because this will affect all our new leases coming up. And we have a whole lot coming up. So I don't think any of us disagree with your point of view, Riley. I think we can all see where you're coming from. And it's not, it's not inconsistent with, I think, what could possibly be a potential outcome. So, I mean, we leave it up to the board to make the decision on this.
Then the other question I had was, you guys are a little unclear, so you provided the board options so that, we had to cut the baby and figure out which side we we're gonna have, right? So, is it an option for the board to consider the appraisal to do both? And sort of kick the can down the road? Because I think if we knew the answer of which one was higher, because I think if you valued with the improvements and then you deduct out the removal cost, the answer may be different. Is that an option to kick the can down the road and just say, appraiser, do both? Your instructions are do both ways.
In all honesty, I think staff actually contemplated that as our first and only option. We wanted to do both, but the applicant felt that they needed to know sooner than later because of that bid package that went to Hawaiian Electric. And again, we don't know what they propose in terms of how they absorb the rental rate in there. We were never consulted on that, so I don't really understand how exactly the rental rates that we come up with per the appraisal is going to affect them. We're okay with going to do both at one time. I don't know that the applicant is though.
Okay.
That's a good point. Yeah, that's a good point. But what I didn't understand was your question about the appraisal based upon the improvements reduced by the removal bonds.
Well, I think an appraiser would look at unimproved land. They would look at valuation of the improvements, depreciated value of the improvements. And then they would look at the obligation to remove the improvements at the end of the term. And I think they would be obligated to factor in that cost. So you might have a certain improvement value now, but in 20 years, you'd have a $15 million obligation to remove those improvements. So I think they have to factor in that future cost of removing those improvements. So I think when you first look at it, A and B, you're gonna say, well, with improvements, it's gonna be more. But I think if you consider the obligation at the end of the lease.
I'm not, Member Smith, I'm not exactly sure, and I'm not gonna speak for our appraiser.
You almost fell out of your seat, right?
We have an appraiser here.
Assessor, not
Assessor.
appraiser. So Stephen Domingo.
Yeah.
So I have assessment background. I'm not a licensed appraiser, but I did work for the city real property assessment for 15 plus years. In this case, the scenario would, I brought up that option of and or because it would be a possibility. But for it being like what Member Smith was saying, it may not be as simple as minusing out that, but it would probably be some kind of discounted cash flow where at this time, say the February 2026, this is what the value of the land is at. They're gonna be doing some kind of analysis where the tenant would probably have to put up some money up front. What's their cost? And then each year they're gonna have a rental income where this is what, they're charging, getting the revenue, but they also have these expenses, and they'll probably do probably a 20-year, assuming. So what they're gonna be doing is saying, this is the cash flow plus minus every year. But then at the end of that 20-year term, they're gonna revert back and say, with all this income plus and minus, this is what the value of the property is as of February 2026. So that would probably be the rationale for their valuation as improved, but as vacant is basically just, this is the land, these are the sales of vacant land, and this is what the value of the land. So there's gonna be basically two appraisals, but it might be in one report.
They're gonna do a reduction of the removable.
They might take that into consideration at the end of that 20-year term, where they might have the obligation to remove it. What's the cost at that time? And that would probably be calculated in their valuation, but are to be taken into consideration. Yeah.
But would that valuation then also include the improvements, the additional improvement? Because they're gonna put in substantial.
Yeah, so that would be,
improvements,
so at the beginning of the term, they're gonna estimate the cost of what
you know, how much they have to put in. So that'll be like on the tenant side, like minus, because that, all that money is going out that they have to, you know, put up to do whatever improvements they need to do. But it's not that simple, and I don't know if, I don't think I would be able to do it, because this is a unique
And Steve,
situation.
My point was, I'm a licensed engineer, so you ask me an engineering question, I'll answer an engineering question. We probably have about 8 attorneys in this room. You ask them legal questions, you can get 8 different opinions.
No, 16.
There are no MAI folks in this room,
Correct.
right?
Yeah.
And so we're trying to make what we think is reasonable conclusion that is not in any of our areas of expertise. But if you do it both ways, and if you give them instructions that you need to complete it by a certain day, then they'll put whatever escalation factors in there to get it done quickly. And then we'll have that information and would give us more data to make an informed decision.
I agree. I think, I mean, like Lauren said, it was all on the applicant, though.
Yeah.
They're forcing us to
And
do it.
maybe we should ask the
one-on-one.
applicant whether they would even be supportive of that. And if they tell us no, then we don't have to consider.
Hold on. When an appraiser walks onto the site, will that appraiser look at this 30 turbines as unimproved land?
If we ask them to do a scope as if it were completely vacant, yeah, they can.
So
can
they
assume
go out
it's-
there and just grass.
Yeah, I mean,
They
like
can't see the 30.
physically
turbines.
they'll be there, but if for their scope of work, yeah, they'll assume that it's not there.
So, but
Yeah.
to clarify that and just to kind of distinguish it, it would be the highest and best use of the land. So this is conservation
Okay, that's what I
land.
said, yeah.
Typically, you can't do much in conservation
Right.
land, but if they do get a lease and the lease does provide for wind power, that would be the highest and best use most likely.
Right.
So then they would not only look at it as vacant, they would look at it as a wind producing facility site. And then they
Right,
would
so
have to
all I was trying
value
to
it
tease out
accordingly.
is it's not just vacant.
Oh, yeah,
Right? Your
yeah.
lens is already highest and best use in my mind.
Yes.
I'm not an engineer, I'm an architect by trade, and I can tell you if a building's on site or not,
Yeah.
right? I can tell you if it's raw land, right? So anyway, thank you for that, Manal.
Nope, thank you. That's a good point. That's good. And maybe I'm gonna take it out of order, but Jody and David. So as staff said, the request to determine the appraisal was at the applicant's request. They were initially gonna come in and say valued at both. Do you have an objection to that?
I think all I mean, I'm not gonna speak for the board, no, and Chair, I think I'd just say, you know, the first point I mentioned, if the improvements revert to the state, we can't secure financing, we can't invest in the facility, and that's probably it. So that's why, that's one of the several arguments we advanced, and
But do you have an objection to the board approving, considering as a third option, to instruct the appraiser to value it at both, to provide us 2 valuations? One is on improved land, as you are proposing, and second one with the current improvements on them. Because if not, the board is going to decide one or the other.
I won't object, Chair.
Okay,
I will
okay,
say
okay.
that it's obviously challenging to get these appraisals done.
Fair
And
enough.
so I think perhaps it was Riley that mentioned, you know, if we
Yes,
can
yes.
find a way to ensure that the
Yes.
appraisals are completed. But I can say that our position won't change, that if we don't maintain.
Can you please come up?
I'm sorry.
I can't
I'm
hear
sorry.
too well, so.
I'm sorry, I didn't,
Yeah, sorry.
no, I just was gonna, to end really with, you know, the board can procure the information it desires. Our position, just as a matter of the way the industry is set up, can't change. That if we don't own the improvements, we can't
Oh, I see.
finance
Okay.
anything in the facility. And so, you know, I would also think about that too, when you're thinking about, well, what are the value of the the value improvements? In order to receive an investment, it must be securitized with ownership of those assets. And that's not our decision. That's how the power industry works, and we can't change that. So we have to retain ownership in order to proceed.
And we're also assuming that the appraiser would engage in something like that, appraise in that manner in which we're suggesting, right? So to Riley's point, I agree. None of us are appraisers. I'm not an appraiser, so.
But it doesn't change your ability to own it. It's just a question of how we're going to value to what we charge you. So if a determination is made that we're gonna value it with the improvements, if we decide to lease it to you, we'll lease it to you with the improvements. You will still own the improvements.
I think
Oh, okay,
there's some, it can get very complicated there if we don't have a complete ownership of those improvements
I see.
to secure financing.
Okay.
as
So
we
you need
do
to, you need
today.
to know that before we enter into a lease?
Yes,
Okay.
yes.
So Chair, but
Yeah, cool.
I have another question. So there's some talk about possibly a third option.
Mhm,
How about being time sensitive
mhm.
for it to happen? How long does it take to get that done, if that were to be an option?
Andrew, how
So,
long would the appraisal take?
yes, sir. Typically, our appraisals, we ask that our appraiser complete it within 6 to 8 weeks. This is a quite complex one,
Mm.
so I'd expect it to go the full 8 weeks, if not longer.
But it'll be completed before we come back to the board
Correct.
for approval of the lease,
December.
December.
So the lease expires in January. The holdover expires in January.
But all of the deliberation December, we'd have to
That's
talk
what
about it.
we're targeting. That's what we're targeting.
Okay, just a thought. Okay, thank
Yeah,
you.
yeah, yeah. Okay. All right, thank you. Thank you, David, for answering your question. Okay, board members. We have a motion.
So Chair,
Yes.
there's been so much talk.
Mhm.
Sorry. So I'm gonna make a motion that we approve staff recommendation, and the recommendations, line items 1, 2, 3, 4. And on 5, I'm gonna approve, ask that we approve 5A as an apple,
Okay.
as submitted.
A motion has been made. Do I have a second? Second. Okay, a motion has been moved and seconded to approve staff's recommendation 1 to 4 and 5A. I'm in discussion. Right?
Yeah, so I just want to reiterate my points from before. So the applicant has already said that if the valuation is including the improvements, that they will not continue in February of 2026. So the benefits that Maui County has and the lower increase in electrical rates for all the residents of Maui will go away. So I know there are concerns about setting a precedent, but I just want everybody to remember that the governor has goals as far as non-reliance on fossil fuels. There are federal disincentives to continue projects like this. So my interpretation is if this motion is approved, Kahiava is going to stop in February. So I just want to make it clear, and that's why I'm going to vote against this.
Sure. Is it okay to call for an executive session in the middle of a vote?
Yeah. Yeah,
Yes, so why not?
Yep.
Yeah.
done it before.
Could I
Sure.
call for an executive session, please?
Do I have a second? Motion has been moved to go into executive session. Do I have a Okay.
So the board may go into executive session pursuant to section 92-5, parentheses A, parentheses 4, HRS, in order to consult with its attorney on questions and issues pertaining to the board's powers, duties, privileges, immunities, and liabilities.
A motion has been moved and seconded. All in favor, please raise your hand or say aye.
Aye.
Motion passes with 7 votes. All right. We're going to be in executive session. You can stay Thank you, everybody, for your patience. We just completed an executive session to meet with our Deputy Attorney General on our powers, duties, and liabilities as it pertains to item D2. Board members, Pua, you made a motion?
I did, thank you, Dawn. So there's gonna be a slight change here. Thank you, everyone, for your patience. I'd like to make an amendment to the recommendation that, an appraisal, where are they? That appraisal will be based on options A and B of the recommendation, and we'd also ask staff to give us a deadline of 8 weeks,
No, instruct the appraiser to get
Right.
it done within 8 weeks.
within 8 weeks. So is the appraiser here?
No.
They have to RFP it.
Okay. So yes, we do want the appraiser to get back to us.
Steph, you wanna come up while you hear the, yeah.
Andrew. No, no.
No, we don't have,
He's a
the
land agent.
appraiser hasn't been.
Appraiser is an on-site consultant. They have
Yes, so he's our appraisal specialist. So he will coordinate all of that and do the,
You could get back to him that, yes, the motion will read that, yeah, we need it to be inclusive of options A and B, and that it revert or be done within 8 weeks, and that we wanted to note that this board is very pro-energy to, you know, to be clear, and we just want you to all know that. And that would be, yes,
Okay, thank you. So,
our recommendation.
Denise, do you approve the second? Okay, so a motion has been moved and seconded to approve staff's recommendations 1, 2, 3, and 4, and 5 to amend recommendation 5 to omit the or, to and then to add a deadline of no more than 8 weeks to complete the appraisal. Thank you very much. With that being said, board, a motion is moved and seconded. All in favor, please say aye or raise your hand. Mahalo. Motion passes with 7 votes. Thank you very much. Okay. Let's move on to item E. Yes, you can go out. And we'll just note that, that you left the boardroom. Go ahead. Thank you. Okay, go ahead, guys.
Good morning, Board.
Good
Women
morning.
Chair, Barry John, Land Division. I was asked to present item D3, but there's not much I can say to be honest. Basically, it's to report on the immediate Court of Appeal opinion regarding Franco and the Board of Land and Natural Resources. At the same time, we also asked for the board approval for the proposed stipulated judgment in the court case. I understand we have a deputy AG present in our room, and that's basically what I have to say at this moment.
Barry, could I ask you, and it's not necessarily on the board agenda, it might be a little out of order, but in one of the testimonies that included photos of what appeared to be pre-setting at the site. Could you provide us an update on what staff has done? When did you receive that notice and what has staff done?
I received the latest email on the Saturday, I believe it was afternoon, early afternoon.
Okay.
The past Saturday, this past Saturday.
Okay.
And Monday morning around 8 o'clock, I was there
Okay.
on the premises at the location, and I walk basically from the airport side, go to the Coconut side, the beach, and walk back. And I didn't see any preset. I saw, I believe, five people. They didn't dress like tourists. I believe they're from the community. And then I saw 2 people in the water. And I ran into a hotel staff who was taking care of the beach chair. He was placing a beach chair right in front of those townhouse guest room of the hotel, which I understand from the past survey that it was on the hotel property. That that's basically what I saw. And I didn't see any beach chairs on that morning. When I came back Monday morning, I'm sorry, real quick. And then I also asked another of my team member to go up to the same site on the Tuesday, the following Tuesday at 10 o'clock, around 10 o'clock in the morning. She came back and reported nothing. No, and no preset. Wednesday, I planned to go out, but I got other commitments, so I couldn't go. But I went yesterday, same time, around 8 o'clock. Same result. I didn't see any beach chairs preset on the beach. And I saw a couple. I think that guy was swinging his golf club, practicing his swing on the beach. That's it.
Okay. Thank you, Barry. If the agenda item does, so I'm going to thank you. Board members, do you have any questions for Barry before I let, there's two people that have signed up, Derek Simon and David Kimo Frankel. Thank you, Barry. Derek, did you want to?
Aloha, good morning, Chair,
Yes.
board members, Derek Simon on behalf of Resort Trust Y LC. I'm not sure if it made its way to all of you on the board, but the hotel did provide Barry and Ian with a response to Mr. Frankel's email that he sent out on this past Saturday. Joey Barra is also here available by Zoom if you have any questions for him. But the hotel is pretty clear there was no pre-setting going on. These are situations in which there's kind of two distinct situations that happened this past Saturday. One was a situation where a guest comes down and requests a chair and they leave, go get a coffee and don't come back and the chair stays out. Or I think another guest had gone from the chair to the room back and forth throughout the day. But their intent was to be using the chair as far as staff was aware. The other two examples in the pictures shown involved guests simply going onto the hotel property and grabbing a chair themselves and setting it out for their own use. The address, as noted in the letter provided to Barry and Ian, the hotel has tried to address that by locking up the chairs during, when attendants aren't there to help out the customers. So I don't have a ton to add beyond that. But again, I'm available for questions. Mr. Ibarra is available for questions as well.
I'll take David Kimo Frankel.
Can I ask a
Oh,
question?
I'm sorry. Go ahead.
I just wanted to check, is it hotel policy that if a guest improperly puts a hotel owned chair into an area, they're not supposed to do your employees counsel that guest?
Yeah, so generally guests aren't supposed to be taking their chairs on their own anyways. I believe that the individuals that took the chairs this past Saturday were, this was addressed by staff with those specific guests. And again, they're going to, lock up the chairs going forward to try to prevent that situation in the future.
Thank you.
Are there site security cameras that have this area in the field of view?
I
need to ask, but we've been dealing with this since I first sat here 7 years ago.
Yeah.
This is when so are there any cameras that?
That I do not know. Mr. Ibarra could probably speak
Joe,
to
do you
that.
know?
Yes, we do have cameras.
Okay, so if there was a challenge and someone could substantiate that in fact there was no place setting, that could be easily cured.
Correct.
Okay, thank you. Thank you, Bill.
Thank you. Any other questions, board members? Okay, thank you.
Thank you very much.
Thank you. David?
Good morning, David Frankel. I've been pursuing this issue since 2018 or so. Hope you've seen my testimony. If you didn't read it, I hope you've seen the pictures. Back in 2018, things were pretty atrocious. And this is before any of you were on the board and before any of these deputy AGs were around.
I was here, David.
No, but it happened to start before, it was before you started.
Before, okay.
The first meeting was, I think, the second year that I brought it up. Things are bad. And a number of us brought our concerns to this board and we were treated with disdain. With disdain, the hotel took over the beach, And a letter was written in 2018 to Suzanne Case saying, hey, documenting, here's all these photos. Your staff went out there and didn't see any violations. We have photographs. They were, even though Suzanne Case had a letter to the hotel saying, you can't conduct weddings on the day we went out there, there was 2 weddings being performed on the public trust land, which Suzanne Case had already said no to. There was no consequence to that. These guys are operating a restaurant on the beach without permission. And instead of cracking down on them, this board authorized the hotel to continue to use beach land and exclude the public. That was wrong. And the board's refusal to deal with that led to this lawsuit. I hope you read and understand the Intermediate Court of Appeals decision. The IC said this board failed to start with presumption of public use. This is public trust land. Failed to consider alternatives to allowing them to exclude the public. There's a clear alternative. They want to put their beach chairs out, they can put it on their own property. I get 5 minutes, Riley. Because I'm one of the people assigning this thing.
I will give you some additional time.
And third, in its decision, this board's decision was very unclear. So the Intermediate Court of Appeals said that summary judgment should be granted to me in this case. In an attempt to resolve the case, the parties have come to a proposed stipulated judgment. I think it's important that you folks as a board, under your constitutional duties, actually vote to approve that stipulated judgment so that you understand what your trust duties are. And because the Constitution requires you to make the decisions regarding the property, not your Attorney General. I also want to request that you folks, you need to have litigation items on your agenda, every single item. 3 of you are familiar with other boards and commissions, Land Use Commission, Hawaiian Homes Commission. Those bodies regularly have litigation matters on their agenda. Those bodies are regularly updated the status of what's going on in the cases. You rarely are. You need to be. I'm asking that you put on your agenda regularly litigation items. I don't think most of you know the cases that the board has lost just this year. These cases are a big deal, and the entire board needs to be briefed on them so the same mistakes don't occur over and over again. It is part of your trust duty to understand the lawsuits that are being filed against you, or that you are suing other parties on. So I would ask that you change your practices, because there's a lot of cases that you folks have been poorly advised on. I don't even know that you understand the arguments that are being made on your behalf. Some of them are just ridiculous, and it needs to stop. There needs to be sweeping changes so that you folks can uphold your public trust duties. In any case, you have the stipulated judgment before you. I don't know if you want to go to not stipulated judgment, stipulation as to come forth. I don't know if you need to go into executive session to discuss it, but I'm here to answer any questions that you may have. Thank you.
Thank you very much, David. All right, board members.
So hold on. I was here the second meeting. Okay,
Yeah.
Fine.
Yeah.
I don't quite agree with the characterization of what you just said about the resort. Yeah, maybe there were some issues that the resort had, there's some wrinkles that they had to iron out. I think that's fair. Would you say, David, that since that time to now that the hotel has made some progress in the right direction?
Vast improvements.
Vast improvements.
But-
Okay, thank you for
but
being honest.
I will say this Saturday, that's just wrong.
Right.
It was employees setting out the chairs.
Right,
It
okay,
is not guests leaving them there. It is employees doing it.
okay, but as far as the weddings, the barbecues, the restaurant, all of that, in my mind, has gone away. So there's progress.
Much progress, and actually a lot of that is because the city sent the notice of
You
violation
just won't
letter.
thank the board, will you? Okay, anyway.
No, I acknowledge you guys last year, what you guys did with the RP was much better.
Right.
And that because the hotel sort of threw in the towel and said, okay, we're not gonna preset. Of course, they've continued to preset.
Right.
Like if you look at the January 1st photo in my testimony, this is after they said they were not presetting. That is outrageous. And there's photos of the staff. You can see the staff member in the photo laying out the chair. And this is both on the grass and the sand. And after, oh, there was a miscommunication, misunderstanding. And then it happened again this past Saturday.
So I'm glad you brought up the RP because I was gonna bring it up. We issued the RP, okay, the hotel, okay, they were amenable to try and do better. Are you asking, David, that the board weigh in even more on top of what, beyond the RP, to control down to the granular level at the staff who may or may not be aware of placing a chair here or there? I mean, it's kind of much, isn't it?
Okay, I'm gonna go interject just so, because that's far beyond the agenda item. The
No,
RP.
because he's talking about setting the chairs, right? And then this guy is saying they don't do it, so.
Listen, what all I'll say is there are lingering issues. And so I want you to know that if you agree to this stipulation, it doesn't mean that all the issues go away.
Right.
Okay, so that there are still problems. And we will discuss that at some subsequent time, like the hedge on the Cocoa Head side of the property that bisects the beach shouldn't be there. All it does is it makes the area look like it's exclusive for the hotel. That's not on your agenda today. It's something we want to discuss. I screwed up. I should have come last week when you talked, or 2 weeks ago and talked about the RP. I missed the meeting. That's on me. So we'll talk about it again at some point, but there are continuing problems. And they will need to be addressed.
Okay, thank you, Chair. Sorry about that.
No,
Thank you, David.
okay, thank you. So, there is the agenda item is report on a request for approval of the proposed stipulated judgment. We have a motion to go into executive session, or are you prepared to make a
Go
vote?
into executive session, Chair.
Okay, thank you. Do I have a second?
Second.
Motion has been moved and seconded to go into executive session pursuant to 92(5)(a)(4) to confer with our Deputy Attorney General. All in favor, please say aye.
Aye.
Okay, motion passes. Thank you, everybody. We'll be. As we wander back in. Thank you. Thank you, everybody. We are back in session. We were in executive session meeting with our Deputy Attorney General on our duties, privileges, and liabilities, and specifically in discussion regarding the proposed stipulated judgment. So with that being said, board members well, let me ask, I think I've closed public comment, Ross. Is there anybody else here in the room that wants to provide the board a comment on item D3? Anyone on Zoom? Joe? Oh, I
It's the
think Joe,
hotel.
he was with the hotel. Yeah, so, okay, I'm gonna close public comments. All right, board members.
Move to approve staff recommendation.
Second.
The motion has been moved and seconded to approve staff's recommendation, the approval of the proposed stipulated judgment on count 4. All in favor, please say aye or raise your hand. Motion passes unanimously with 7 votes. Thank you very much. All right. Thank you, Barry. Let's move on to item D1. Stephen, is that you? Yes. Very good. Thank you.
Chair Chang, board members.
Good morning.
Morning. I'll try to keep this brief. This is for the Island Foy revocable permit renewals. Based on the last 2 meetings for the Kauai and Oahu meetings, we are taking into consideration the board's comments and concerns, and we are actively planning to address the concerns for the next year's renewals. So we are gonna be doing a little more detailed explanation and why there's no long-term disposition for the revocable permits.
We're moving them towards long-term.
Yeah, or the plan to move them to long-term dispositions. But so in exhibit 2, there's the 2026 recommended rents amount, and then the rationales. Most of them are 3% or recommending 3% over the 25 rents. 13 of them are to government agencies at gratis, and there are 2 that we're recommending 15 and a 10% increase. But those are type 1 or former type 2s that are now type 1. So we're bringing them at the 2018 value or market values. The other type 2s, most of them are recommending 10% increases. To address some questions that came up, RP 7733 is a type 2. We are recommending a no increase on that one from last year. The district needs more time to double check that the rent amount is based on the actual leased area, because there were some changes from the original RP. The land area that they're using is smaller. It's now 530 acres. So staff needs more time to just verify that the rent amount is based on the actual area that's being used. Another question came up on a couple of the Parker Ranch RPs. One is 7652. There may have been some misunderstanding in the comments where it says that, as resources permit, it's more, we're talking about as our staff needs time and resources to look into it a little more closely. This was identified by the Department of Ag and Biosecurity requesting it to transfer under Act 90, but we have to look at why it was not part of last year's this board's agenda in October 2024, where we had a giant list of all the Hawaii County ones that we were recommending to transfer, but for some reason this one was left off that list, and at face value, you can't see why. So we need more time to look into that.
Sure. Question?
Yes.
Regarding what you just talked about?
Yes.
So when does it reappear on this spreadsheet next year?
So it currently is on this worksheet for renewal.
Is this what is the latest status on 7652?
Right now, we're just recommending to keep it as is. But the Hoi district, they're gonna be looking at, or confirming with DOFA to see if they want to keep it in, in their, purview. And if not, then we may look at bringing it to another board, meeting to maybe, recommend,
Thank you.
transferring.
My comment was just because of a written testimony from someone from the Big Island, asking to better.
No, we were gonna do it regardless. It's just that I think there was some miscommunication or misunderstanding of our wording as saying, as resources permit. I think they thought that we're looking to do a resource permit, which is not really a thing. It's just that we just need more time.
Maybe public option,
Um,
public option. as-
that may be, it may be an option but I mean, but it's more for just the staff still needs more time to look at it.
Okay, just so that it's on record that I do not support selling leads associated with RP 7652.
Sorry.
I think Candace wanted to make some comments.
Oh, yeah, Candace is.
Say what, Lauren?
Oh, Candice and Doka is on if you have questions for them regarding some of the RPs.
Well, primarily, I just want to make that comment, Candace.
Yeah.
Steve,
Candace Martin, the acting district land agent for Hawaii Island.
Yeah, so I'm talking about.
Hawaii District Land Office has
7652.
absolutely no plans to put that property up for auction at this time.
No plans, okay.
Apparently, that comment is an artifact from previous years that showed up on the spreadsheet, and my bad, I failed to see that and get it removed.
Okay, thank you for that. Thank you, Lauren. Thank you, Chair.
Okay.
All righty, or did David, Stephen, did you want to complete your presentation?
Yes, okay, so another RP that came up was 7659. We're recommending a 15% increase over last year's rent because at least the past 2 years prior to this, it was being increased 15% over subsequent years. This is one of the ones that had the PAR, the 2018 value, and it is catching up to it. So this year it will be at that PAR value, which is, again, I just gotta reiterate that it was based on a 2018 value, but we were recommending to just be consistent with the 15. If we do, without going forward, assuming we still have jurisdiction over this RP, it would probably be recommended the standard, like 3%, like the rest of them.
What's the status? Why hasn't it moved over to DOA? Are you in the circle?
I know, we are actively working on transferring a lot. I was gonna touch on it in a bit, but there's a small handful, about 5, I believe, that have actually been transferred this calendar year. And then there's a bunch of other ones that we're actively working where they're in different stages where either the surveys are being done at surveys, and there's a few small handful that are at AG or they're being drafted. The executive orders being drafted. So it is moving, just a little slow.
The priorities for that, there were at least 5. These were that the Cattlemen Association had requested. So we're looking at doing that, right?
Yeah, so I don't have the exact permit numbers. We do have a bunch that are actively being transferred, and there should be a couple more relatively soon.
I will follow up with that and get back to you on those.
Yeah, because I've been requesting updates from both DOFA and Land Division. There's 5.
5 priorities cattle association
Yes,
request.
that we had represented that we were going to put those on Land Board's agenda either October or November. So if you can follow up with that. Thank you, Lauren. Candace. 2 of
I'm
them
working
Yeah, I'm sure you are. Thank you, Candace. 2 were not. 5 of them were moving.
Yes.
Yeah, okay. Thank you.
That was basically all I had.
Questions?
And I just want to make a comment, Steve, your staff, Steve Bergfeld, Candace Martin, Nick Ferrera. Thank you so much for entertaining my questions. I try to reach out to the community and get their feedback. And I think they're pleased with your ability to respond promptly to the concerns they asked. And especially the one having to do with 7652 and potentially taking that off the public auction. That was a big concern. What a lot of the ranchers do is they have fee simple lands, they have lease lands. And even though they don't have the same land tenure, they enable the ranches to have continuous access to move their cattle between different paddocks. And Parker Ranch used to have a lease with DHHL of Hawaii Preparatory Academy that was removed from their lands that they owned, which complicated their ability to be profitable, to enable them to run an operation that employs people in Waimea. It provides food self-security and all those concerns. So I just appreciate your staff working closely with these different ranchers and landowners. Thank you very much. Thanks, Candace. Thanks, Steve.
Chair,
Yes, go ahead.
before we proceed any further, I'd like to make a disclosure
Oh, yes.
related to RP 4135 to the Roman Catholic Church. The nonprofit I'm employed by, which is Catholic Charities Housing Development Corporation. It's a 501c3 nonprofit. It's an affiliate of Catholic Charities Hawaii, which carries out the social mission of the Roman Catholic Church. They're separate legal entities and just have distinct governance and financial structures. I'm not involved with or have any knowledge of this RP, but in an abundance of caution, making this disclosure doesn't affect my ability to be fair and objective.
Excellent. Thank you. I don't, is there anyone here that has an objection to board member Denise, Matsubara continuing to take action on item RP 4135? Okay, seeing none, thank you for the disclosure. And I appreciate starting off the presentation acknowledging that at the last board meeting, the board members did ask that staff come up with a more strategic plan on, as you say, transitioning these to longer term leases from RPs, looking at, the Act 90 leases, looking at, how do we, and I know I've talked to the department and I'm willing to provide you additional capacity to do site inspections on these to ensure that they're in compliance. So I recognize that at this point in time, you haven't had the opportunity to make those to address those issues, but next year we are assured that you're going to do that.
Yes.
I also would like to add to your list the 5 residential properties on Hilo Bay Drive. This is the one 7884, 7886, 788. That these are residential. Oh, actually, there's more. 7873, 7874, 7576, 777. They are all residential properties. I've done some site visits to that place, and some of them look like they're in good shape. Many of them look like they're. I think I've driven out there with Candace, and it is, some of the properties are a real blight. So if we can, and I know it is a capacity issue, but if we can address a strategic plan for what are we going to do with that? Because now that DOT is not interested in taking that parcel back, is there something that we can look at? Including workforce housing.
Just to make that comment,
Yeah.
that is industrial zoned.
But we've got these residences on there though, right?
They're grandfathered.
Okay, but we have residences that have been on there for a long time.
No new permits for residential renovations even are being issued by the county.
Okay, are any of those vacation rentals? Do we know?
No.
Okay. Well, I am just, as a matter of policy, well, we've got residential properties and we've got private citizens, residents living on them. I don't know whether that's feasible, but I would like us to consider how can we make public, these potential public residential parcels available to, for workforce housing. May not happen. I just want that to be a consideration. Okay. We have a hard enough time keeping state employees. If we can make it easier, even as we're traveling, rather than having to pay for hotels, possibly, can one of these sites be made available? But that's just for consideration. Board members, do you have any other questions about specific agenda, RPs?
Quick question about the 3% pasture ag land. I get it. What is gained by the 3% at the end of the day?
Is to account for the market, because most times in Hawaii, the market's always gonna go up. So back in the 2018, when they did the PAR analysis, the appraiser did recommend a 2 to 3% increase annually for RP. So we're kind of sticking to that 3%.
So that's what's gained on the landowner side. What is gained on the lessee side? In other words, if the 3% was, and that's not what I'm suggesting, but if the 3% wasn't there, which is, $100 couple dollars, or, less than 1,000 in a lot of them, what value does that bring to the guys that are ranching?
Member Smith was saying, they can continue to do their operations and
Pay more?
continue.
I paid more?
My understanding is that part of Act 90 is to transfer it to the Department of Ag because they're better suited for these type of operations. And when they get control over the RP, they may be looking at different rents, and they're a little bit more capable as far as monitoring or managing the ag rents or ag permits.
So for example, a current rent of $556.44 going to $573 makes that adjustment.
So for our purposes, for land division, that mean
No, for the rancher.
to me it's big scheme of things, it's kind of a nominal when you're looking at, because that's the annual.
Nominal. That's my
Yeah.
point.
But then again, it comes down to we're not really gonna be putting too much resources into trying to figure out a better, or I guess a more current rent, because that 2018 valuation costed us about 400 something thousand dollars. That was only about 110 permits.
Okay,
So
okay. I just got a few emails. That's why I'm asking. So
Okay.
thank you for that.
Board members, are there any other questions on on the revocable permits? So I appreciate that some of these are really long-term and that you are strategically looking at. And I know that Act 90, it currently requires both DLNR and DOA to agree. Because I've been receiving some comments about these additional leases, if they were extended another 65 years, questions about privatization of public lands. So I think we do have this part of our public trust analysis, ensuring that these lands, there is a public trust benefit when we look at that. And I have greatly appreciated Land Division really, I wouldn't say embracing that, but incorporating that as part of your analysis and taking the time to do that on each one of the parcels. That's been very helpful. Thank you. Okay, board members, let me ask, are there any members of the public here who would like to provide comments on D1? Anybody in that? Okay, is there anyone on Zoom, Ross? Closed public comments, board members, do I have a motion for item D1?
I move that we approve item D1 as recommended by staff.
Second. Motion has been moved and seconded to approve item D1 as recommended by staff. All in favor, please say aye. All right. Motion passes unanimously with 7 votes. Thank you very much, both of you.
thank you.
Thank you.
Thank you. We are now going to move on to, a request has been made to move up item F2. So, Brian? And let me, for the record, is it J1, secure parking. County, we're probably not, I'm gonna try to go through these F1 and F2 before we do J1, okay? We're probably not gonna take a lunch, we're just gonna go right through. They can eat afterwards. A lot of you, if you're here for different items.
I don't share that sentiment.
Okay. Because I will begin to start losing some land board members, so I'd like that. Okay, Kathy and Brian?
Okay, aloha Chair, board members, Brian Nielsen, Administrator for Division of Aquatic Resources. Also joined by our aquatic biologist, Kathy Gajewicki. We also have representatives from the Monterey Bay Aquarium with us today, George Peterson, George Matsumoto, and Manny Azkura as well. So item F2 is a request for approval of a special activity permit 2026-35 to George Peterson of the Monterey Bay Aquarium, Director of Marine Operations, to collect, possess, or transport regulated and non-regulated organisms, including various species of gelatinous zooplankton, and jellyfish in a regulated area, the West Hawaii Regional Fishery Management Area, also known as the WRFMA, and non-regulated areas in offshore waters of West Hawaii using non-regulated gear for the purpose of educational live display in a deep water exhibit, in quotes, aquarium purposes and associated research, e.g. husbandry, captive research, and culturing at Monterey Bay Aquarium, Monterey, California. So some of the board members may recall back in August of 2024, we had brought this permit to the board, and the board deferred the item and suggested that the applicants do some more consultation with community members, Hawaiian practitioners. There was also suggestions to reach out to potential collaborators in Hawaii as well. So since then, representatives from the aquarium did reach out to DAR, and we provided some references of contacts in West Hawaii, and they've done quite a bit of consultation with practitioners and community members, and also, you know, we're very open to this idea and open to learning more about West Hawaii and Hawaiian culture and Hawaii communities. And we've made some modifications to the permit as well. So Kathy is going to go through the submittal in more detail, but I did just kind of want to catch us up from where we were at from a year ago.
Yeah, thank you. Kathy?
Hey, aloha, Chu Chang, members of the board. Yeah, I'll just provide a little bit more information about the permit and the submittal, and then I think members of the aquarium want to give a short statement as well and can answer any questions. So this project will take place in the pelagic environment in waters that range between 4,000 and 7,000 feet deep offshore of Honokohau, Hawaii Island, in between 2 to 20 miles offshore. And so one of those miles is within the regulated area, the West Hawaii Regional Fishery Management Area, but the majority of the miles would be outside of state waters. And no collections will occur near shore or in any type of coral reef environment. These collections will support the Deep exhibition that opened in 2022 at the Monterey Bay Aquarium. The species to be collected consist of the following. There's some photos of examples in the handouts I just gave. They're also in the submittal for anyone online. They consist of gelatinous zooplankton, which are defined as organisms that remain gelatinous their whole life cycle. So the transparent organisms you see, just regular zooplankton, which consist of organisms that are gelatinous in their larval or planktonic stage, but may settle out to become things people recognize, such as crabs, brittle stars, squid, octopus, lobster, and lobsters, and also jellyfish. After the organisms are collected, they'll be collected offshore and then transported to Nelha in Kailua Kona for temporary holding and then transported to the Monterey Bay Aquarium for to the exhibit or to be utilized for culture work. Up to 750 specimens are proposed to be collected. This amount basically fits into a reusable water bottle. The main changes proposed for this year consist of the following: the removal of the Fisher seahorse, which was included last year, and a few other species, which included like the nautilus and a few other species of squid and octopus. And then the addition of any new outreach collaboration or consultation activities that were conducted over the last year or are planned for future years. Examples of this type of outreach and collaboration or consultation included a public presentation on blackwater diving, which was provided at NELHA in July of this year. And these presentations are planned to occur on a regular basis, about 2 to 3 times per year, including one after the collection period. And engagement that occurred included community stakeholders and cultural representatives, such as Aha Moku Council, Nili'i community-based subsistence fishing area, and Hui Aloha Kiholo. Educational outreach efforts have occurred with the University of Hawaii and West Hawaii Explorations Academy. In addition, there were 2 letters of support that were provided both by UH and ULEA as well. And DAR does not anticipate cumulative impacts to occur as a result of the activities. We can provide more information on that if there are questions. But as I said, the MBA staff, members of the MBA staff are here. George Peterson, Director of Dive Programs, and then George Matsumoto, who's a Senior Education and Research Specialist, and Meni Ezkura, who's the Curator of Fish and Invertebrates. And I think George has some information for that.
Thank you for bringing your team.
Aloha, Chair and members. Good almost afternoon in 5 minutes. My name is George Peterson, and as Kathy mentioned, I'm the Director of Marine Operations at the Monterey Bay Aquarium. And we're here today to answer any questions that you may have and to respectfully request approval of our special activities permit to continue our unique partnership with the state of Hawaii to conduct research and educate the public on the pelagic plankton found in deep ocean waters all over the world, including a few miles off the coast of Kona. Now, the Monterey Bay Aquarium is a 501c3 nonprofit public aquarium, educational and conservation organization. And MBARI, the Monterey Bay Aquarium Research Institute, is a nonprofit research organization that we collaborate with on many initiatives over many years, including our Into the Deep exhibit, where these specimens are currently displayed. Now, we believe, and we have data to support over many, many years, that through living exhibits, we inspire and motivate the public to understand the need to protect the ocean, the animals that live in it, and their habitats. And we're very fortunate that our reach is vast, and we inspire millions of people through our exhibits every year, both living and virtual. And at MBA, we have educational and admission programs that annually bring hundreds of thousands of school kids and low-income residents of all 50 states through our doors at no cost to them. Now, part of our outreach as well is to work with public aquaria all over the country and all over the world, teachers, academia, researchers, including many people and institutions based here in Hawaii to understand and share all that we collectively learn. And at the aquarium, we strive to be inclusive and culturally sensitive. We strive to conduct rigorous and ethical scientific research, and we educate and engage diverse audiences on the amazing array of life in the world's oceans. We tell the story of the ocean itself. And on a personal note, I would like to thank the board for the deferment last time, and many of the BLNR board members and the DAR staff, Uncle Charlie and Uwe, for the guidance over the last year and a half. It's been a really wonderful journey for us. We've learned a lot. And I would invite any board members or any DAR staff members to come visit our lab at Nelha to see what we do, or also extend that invitation to the Monterey Bay Aquarium. And mahalo, we appreciate the time and all the energy you provided for us here today, and we're available to answer any questions if needed. Thank you.
Thank you very much. And mahalo for taking the board's deferral in the spirit that it was intended, which was really to enhance and to encourage you through the consultation to have a good understanding of some of the concerns that were raised. I don't see them here. I don't know if they're on the screen, but I think that's a good indication. So thank you for, again, taking our recommendations, embracing it in the spirit that it was intended. Thank you. Board members, yes, Lenny.
Yep. Thank you for joining us today and bringing your staff. I want to ask a couple questions, just enter it for the record. So I think the last time you were here, there are some concerns about what you learn when you collect these samples and how similar institutions in Hawaii benefit. Can you let us know what your sharing, information gathering, collaboration is with Sea Life Park, Waikiki Aquarium, and the Maui Ocean Center?
Yeah, absolutely. In public aquarium world, most of the information that we learn is collectively shared. It's non-proprietary. And we have routinely shared information with the Waikiki Aquarium over the course of many, many years. And they have shared much information with us as well, especially in the realm of culturing when we first started out. And so the way it kind of works in our world is if there's an institution that's going to engage in some research or build an exhibit, they will reach out to the local, or not to the local, to the wherever folks are doing that, whatever institution is engaged in that work or has experience in those exhibits, and they'll typically come and visit us. In the case of the Waikiki Aquarium, we've had direct correspondence with them. We've had conference presentations, scientific papers, workshops with many different organizations. Also the University of Hawaii. So we don't just limit it to aquaria. And so it's a very open book in regards to public aquariums and how we share information and what we have learned.
Okay. Couple other comments. So can you elaborate more on your collaboration with University of Hawaii Institute of Marine Biology?
Yeah, so we have for years been a collaborator with Dr. Kim Holland at HIMB. Kim Holland doesn't necessarily work in plankton. Not a lot of people get all excited about plankton like we do. But we have worked with Dr. Holland for many years on sharks, on fishes here in Hawaii. We've funded postdocs, we've funded equipment for them. They have a net pen that they do captive research on tiger sharks that we also funded so that we could also partake in that research, not with any sort of idea to exhibit a tiger shark. We've never done that. But we've had a long and fruitful relationship with HIMB over preceding my time at the aquarium, which has been 23 years. So quite something.
Great. Last comment. So I know you've been in touch with Ahamoku, and I just wanted to point out that Charlie Young was one of the plaintiffs that resulted in the Kapakai analysis requirement of all state agencies. A lot of these folks kind of regularly give me feedback, and I take it as a positive metric when they don't contact me, that they're very pleased with the outreach you're doing. So that includes Charlie Young, who's the Hawaii Island Ahamoku representative, Uilani Naipo from Miloli'i, and also Chad Wiggins at Kiholo. And if you get the support of Kiholo, the group at Kiholo, what you do also is you get the support of a lot of the families in the area of Kapulehu, up at Puwawa, and a lot of the other areas. So Chad may not seem necessarily like a Kama'aina or a local person, but everybody that collaborates with him is. And so you really do get the grassroots support of the community. So thanks for making that effort.
Yeah, thank you. We had an in-person meeting with all three of those folks. We sat on the beach and just talked story and had lunch, and we learned a lot. We kind of went on a learning journey with all of them. And then we've had regular communications over the course of, the last 13, 14 months, including a really great Zoom meeting last night at 4:00 with them where I can't put words in their mouth, but they absolutely support our effort. It certainly seemed, and they told us so. So thank you.
Excellent.
I'm good.
Okay, thank you so much.
George, I have a question, Mr. Peterson. So right off the top, the permit description, you list lobster. Correct? So lobster is a delicacy for Hawaii, for anyone for that matter. So how do you, what's involved in lobster being part of your project?
Wish I had my phone. I would show you a picture of so we collect the larval lobster at a larval stage and display them. So they're not grown. And we collect typically 2 to 3 of these larval stage lobsters a year annually per our permit. Dr. Matsumoto looked up some information for us and we went over it yesterday, and the animals that we collect that are on the permit typically spawn a number of times a year, from 100 to 500,000 animals at a time. And we collect 2 or 3 a year. So we feel that that's very negligible, and they're at a plankton stage. So they look kind of like a jellyfish that may grow into a lobster someday.
Okay, so I just have a comment. I mean, you can take all the jellyfish you want. We don't eat that, but we do eat the lobster. Thank you.
Deep sea lobster.
Does anybody eat jellyfish?
Yeah, these lobsters, thank you, George. These lobsters are typically, so when we're doing this work, the reason why we come to Hawaii and Kona especially is pretty much one of the largest biomass migrations on Earth happens every night a couple miles off the coast of Kona. And these animals come from thousands and thousands and thousands of feet deep. And when we're working, we're floating in about 60 feet of water under a boat, drifting. We're plankton as well. And we're in 5,000 to 7,000 feet of water. So these animals, tiny little plankton, come up from the bottom to feed in about 60 feet of water and go back down. They're not edible well, I guess you probably could eat them, but they're not edible at that time. They're not found on the reefs. They're not part of a fishery. They're essentially in a planktonic stage before they develop into the various species of lobsters that they become.
Thank you. Thank you.
Can I ask you, those of you you've engaged with this community over the last year, how's that impacted you? How's that enhanced what you're doing? How's that affected the project?
That's a really good question. It caused us to be introspective. And we strive to learn, and we strive, as I mentioned, to be culturally sensitive. And we thought that we were acting in that way when we came here, and we've had these permits since 2018, right? Well, we learned differently. And I specifically learned to listen to people's stories and listen to the story of their community and their culture. And instead of taking the tact of, we're here to inform you what we're doing and may we please have a permit, it became more of a, we're here to ask your permission to do this, because we realize the cultural significance of even one small jellyfish or one small lobster, right? And so that has changed how we approach all of our permitting activities, not just in Hawaii, but everywhere.
I appreciate that. I mean, I think that that's for many people in the Hawaiian community and those who came at last meeting. It's so much of this, they just feel like sort of, it's just extraction. You're just taking and not giving anything back, but also not understanding where they come from, the point of view of, as you say, every animal is important. It has meaning. So again, I really appreciate the fact that you took the time to do that. You really heard what we said, heard what the community said. And it has just not only enhanced this project, but everything else that you're doing. I think that really was the intent, and I think also of what the community was asking. So I'm really pleased to see that being integrated in all that you're doing. And I was at a Lavaia Pono meeting with Luna, and these are local cultural practitioners, they're fishers, including Ui was there. And she took the time out to even acknowledge the work of the Monterey, and that if everybody could, come out like how you guys did to talk to them, and as you said, more asking permission than just taking. I think that's the cultural consistency. So thank you again.
Yeah, thank you. And we also believe that every single organism and animal in the ocean matters. And we amplified their story as well by collecting 2 or 3 or 4 or 5 of them, by culturing them, by displaying them. We tell their story, and we have found, and we have data that shows that people make a connection with these amazing, beautiful animals that we display. And what do they want to do? They want to go and protect them. They want to learn more about them. They want to conserve them. And so we feel that it's a very effective method to educate the public. And the mission of our aquarium is to inspire conservation of the ocean. That is what we do. That's the business that we're in. Yeah. And so, yeah, thank you.
Thank you.
Chair,
Board Member Su.
I have a question.
Yes,
Chair,
please
I
go
have a
ahead.
question for staff. No, the numbers on your chart, the regulated organisms, like the first one is for some kind of lobster larvae. You guys mentioned 2 to 3 that is collected, yet your number in the column says 200.
Yeah, I think that's so we do this often with permits. So if an applicant gives us a total, and for this project, the total amount of organisms they propose to collect is about 750. But it's opportunistic collection. So when they go down on the dive, they don't know what they're going to encounter. So you kind of have to allow for more than would normally be collected of each species, just in case, they don't get a wide array of all the species to collect the regular amounts from. So we would be allowing up to this amount to be collected per species because they have, limited capacity to do the dive. So you need to collect what is available to them on the dives. But it's likely that they won't collect up to that amount per species. It's just, it allows for it, but it probably wouldn't happen, or maybe you can speak more to that.
It wouldn't happen. That's
2 to 3 versus 200.
yeah. The permit lists 200. We don't have the capacity for that many, nor the need. We would just display. We literally 2 to 3 to 4 to 5 maybe a year, and that's about it.
Okay.
And everything that we do collect, obviously, we report back to DAR as well.
We could maybe work with you to amend these numbers if there's a way to
Absolutely.
bring down the amounts. Yeah, I think this happens often in order to just kind of allow whatever the division feels comfortable with the amount to allow for, it's really hard to determine what's going to be in what place when you go out to collect from a reef. Even just this isn't collection from the reef, but to collect in any area in the ocean. And so you kind of have to allow flexibility, but we can work with the applicant to make more realistic numbers.
So the 750 that you mentioned, that's for the total of all species together? Okay.
Yeah, so the whole, if you're looking at this table, you wouldn't add up you wouldn't tally all the numbers. It's just that up to that amount per species can be collected.
Thank you.
But we can work to revise them.
Yeah, I echo the sentiments of Chair and Riley. Thank you for taking our our conversation to heart and going out to Iloli and out for Charlie. You said three things that stuck out in my mind in a good way. I'm not gonna beat you. I beat you guys up the last time. First thing you said is key, and give me chicken skin. It says you have to ask permission. That's, bro, that is Akamai. That is right on. Not of this board. You don't ask us permission, other people. Number two is you said one of your goals or mission, I think you said, inspire conservation of ocean, right? As water people, as people from the ocean, that's huge, right? I mean, we ocean people, Hawaii. And then tied to that on the third, you said where you're going is the largest biomass migration on Earth. Is that correct?
One of them, yes.
One of them.
Yes.
So science has taught me as a Hawaiian that Hawaii is also the most isolated habitated landmass on the planet Earth. It is also the endangered species capital of the world. It commands 11 or 13 world climates. What I'm saying as a Hawaiian, and I'm jaded because I'm like, Hawaii to me is a sum total of greatness, of mana. And you tapped into a part of that and you're asking forgiveness now. So mahalo to you guys and your team. I really appreciate it from my heart, from my ohana. I really appreciate, because a lot of times, this board can be tough and, people take it the wrong way. To Chair's point, you guys took it the right way, I think. Some people take it the wrong way and then they grab their toys and they go, but not you guys. So kudos to you guys and mahalo.
Did you guys want to add anything more since you're here?
I guess.
If you just introduce yourself.
No, George Matsumoto, Monterey Bay Aquarium Research Institute. I'm a scientist and educator. I've been able to publish papers with the Waikiki Aquarium on box jellyfish at the Nasatorium, where we found a species that nobody knew lived there. It's really tiny though, so it's okay. But speaking about the numbers that we see, I've been blue water or black water diving for over 40 years, all around the world. And the reason I like it is because you never know what you're going to see. And so we may come out here for 5 days, which is 5 to 8 days, our typical length, and we may see no lobsters, ever. You can't collect what's not there. We may see lots of stinging jellies. That's okay, because they look beautiful on display. So we collect what the ocean gives us. But we will never collect more than we need. And I guess that's what I'd like to say. And we are learning so much from the ones we're collecting. We're keeping them alive. The aquarium's keeping them alive. We're raising them, some of them through life histories that it's never been done before. We think we have discovered an undescribed species here that we would like to work with the community to give it a name that recognizes the importance of jellies in Hawaii. Because one of the issues that we found is that there's really not a lot about jellyfish in the old Hawaii, mostly about stinging. But there's so much more than stinging. They're so beautiful. So we would like to try to bring that appreciation and get some help from the community to help describe what we're seeing. So thank you.
Thank you.
Thank you. Board, I just wanted to say thank you for taking the time to consider our request and for your words. Just to add on to what George, my colleague, was saying, we as a community, we always try to help each other with aquarium projects. So we've been in touch with the Waikiki Aquarium staff about some culture work they wanted to do on cuttlefish. So we had some species of cuttlefish they were interested in, flamboyant cuttlefish. And likewise, when we learn something like George was saying, we do presentations for our community of aquariums so that they can learn from us. And really, the idea is to put the information out. It's not to hide it. And so there was a recent presentation done about blackwater diving and the shipments of animals. When we're doing this work, sometimes we don't know where we're going to end up. Because like George and George were saying, so little is known about them. One advancement, we're always striving to culture animals, and sometimes it's just hard. There's a missing part of the recipe you don't know. Sometimes when we're fortunate, we might have some delicate animals that we can spawn at the lab at Nelha and ship fertilized eggs and larvae, and they develop. And when we receive them, we continue to spawn them. And so that's a great solution. Sometimes it doesn't always work that way, but we're always striving to learn when we can. And when we do, we try to share that information. So thank you for your time.
Thank you, thank you. Is there anybody else in the boardroom that would like to make a comment on item F2? On Zoom, I see Kim. Did you want to provide us a comment on F2?
Yes, Chair and Board. It's like deja vu being back here. I think we have a question today. Do we manage our resources by science or hypocrisy? You see, the AZA, the American Zoological Association, has historically always worked with the aquarium fishery in Hawaii to obtain specimens, Monterey Bay included. Now they want to cut lines on local fishermen that are still out of work since 2018, as they mentioned that they started to come to you guys for permits in 2018. You think the out of work aquarium fishermen don't want to catch a few specimens too? They did not they maybe did reach out to some community members, but not the ones most impacted by this proposal. Is the aquarium community not part of their reach out process? On a management by science point of view, I support this, but at a later date. I would encourage you to defer this until the local commercial aquarium fisherman has had an opportunity to get their lives back and their jobs. Giving a commercial out-of-state aquarium an exemption while your local fishermen are still told more process is hypocritical. You have fishermen that have completed the EIS process 2 times, told to wait for the courts to uphold it, which they did all the way to the Supreme Court, have to come to this board 13 times over 3 DLNR chair administrators. They have been determined sustainable not only by DAR science, but NOAA fishery science, and are still not fishing. Please decide if you manage by science or hypocrisy, and please start being consistent, because even having this proposal on the agenda today before you address your local out of work fishers is quite frankly a slap in the face. And, with all due respect to the Monterey Bay guys, they say they reached out to the Waikiki Aquarium and, got some guidance. Well, the Waikiki director, now he's former director, put them in touch with the fishermen, and they said they had no communication. I have an email thread with George Peterson, John O'Sullivan, George Matsuyama, and John Hoach, and they did not want to talk story with the fishers of West Hawaii. So I urge you to defer this until you handle the aquarium fishery that has complied with everything. Thank you.
Thank you very much, Kim. Chris, did you want to add anything? I see Ron Tubbs. Ron, did you want to provide a comment?
Can you hear me, Board?
Yes, we can. Yes, we can.
Okay, let me try to get my video on. Excuse me. Here we go. Anyway, let me go ahead and continue. Thank you so much for your time, Board, and Monterey Bay Aquarium. Great presentation, and a lot of work went into this and a lot of consideration. That's greatly appreciated. I too, former aquarium fisherman, and highly believe in the fishery. I know it's sustainable. 10% of the fishery was always Hawaiians. I have a soft space in my heart for Hawaiians. I've employed Hawaiians. I've dove with Hawaiians. Very concerned about the direction the culture has gone. The aquarium fishery in Hawaii has never been about foreign people coming in and taking fish. Every member of the aquarium fishery in the past is from Hawaii, not from outside of Hawaii. That said, I do support this permit. I do support science. Without science, we wouldn't know that the fishery is sustainable. We wouldn't know that there's 100 to 500,000 fry per spawn of lobsters. We wouldn't know that, maybe only 1% of those lobsters survive to adult breeding stage. But with a large population of lobsters producing those kinds of numbers, it's very easily to be sustainable. Not to say we don't have problems with lobsters. It is a high demand item, and a lot more than a few aquarium fishermen are after lobsters. You got the tourist groups and all the Hawaiians and all the fishermen statewide. So it is a species of concern, but removing a small percentage of the lobsters in the open ocean should have no significant effect, considering population breeding numbers and the ability to that only 1% is going to survive to adult breeding stage anyway. The lobsters and fish in West Hawaii populate throughout the Hawaiian island chain through currents and broadcast breeding, usually 3 to 4 months open ocean seas, and the resettling on the reefs near shore to begin its journey to adult breeding stage. So the effects that this permit will have on the ocean and the population of the ocean is insignificant. As far as the Hawaiian concerns, God bless
Ron,
every.
can you summarize? Can you summarize?
That's enough said for now. I'm in support. Thank you.
Thank you very much, Ron. I appreciate you being here. Chris, did you want to add anything?
Aloha board. Sorry, I'm Chris Teague. I'm with the Division of Aquatic Resources, District Biologist for Kona. Yeah, nothing to add, just here on the staff side to help as needed. Thanks.
Thank you very much. I just want to clarify and confirm. The species that you are collecting is for scientific research. You are not selling them for commercial purposes.
We do not sell animals for commercial purposes. We never would. And we're not allowed to by our board of directors, by our accreditation status. We are not in the business of selling fish. No, and never will.
Okay, thank you for confirming that for the record. All right. Is there anybody else, Ross, on Zoom? Okay, I'm going to close public comments. Board members, do I have a motion for item F2?
I move that we approve item F2 as recommended by staff.
Second. Motion has been moved and seconded to approve item F2 as submitted by staff. All in favor, please say aye or raise your hand.
Aye.
Okay, motion passes with 7 votes. Thank you very much. Thank you very much, gentlemen, and we appreciate you coming by.
Thank you all.
So we're going to go back. We're going to take item F1. And I am losing board member Smith, but I still have a quorum. So thank you very much. Thank you very much.
Ready?
Yep.
Okay, this is item F1, and I'm Brian Nielsen, Administrator for Division of Aquatic Resources, also joined at the table by Charlie Taylor, who's DAR's Policy Specialist. So this is delegation to the chairperson for the appointment and selection of a hearing officer to conduct all hearings for the court-ordered contested case hearing regarding agenda item F5 from the board's April 26, 2024 meeting, enforcement action against Jim Jones, Noelani Yacht Charters LLC, Kevin S. Albert, Kimberly L. Albert, and the Albert Revocable Trust for unlawful damage to Stony Coral and Live Rock resulting from the February 20th, 2023 NACOA anchoring incident outside of the Honolulu Mokuleia Bay Marine Life Conservation District island of Maui, and admission of Jim Jones and Noelani Yacht Charters LLC as parties to the court-ordered contested case hearing. And I'll hand it over to Charlie to just quickly summarize the submittal.
Aloha, Chair
Aloha,
Chang,
Charlie.
members of the board, good afternoon. It's afternoon now.
Yep.
Yeah, I think this submittal is fairly straightforward. As written, as Brian said, we're just asking for the delegation of authority to the chair to appoint a hearing officer for a court-ordered contested case hearing. This is our standard procedure. Whenever we have a contested case, is we try to get authority to delegate authority to the chair to appoint a hearing officer. The second part of this is to admit 2 additional parties to that contested case. This is Jim Jones and Noelani Yacht Charters LLC. Those were both alleged violators in the previous actions. So as you all remember, this is the 5th time now we've come before this body on the NACOA anchoring incident. Jim Jones, Noelani Yacht Charters, and the Alberts were our three parties to this case. The Alberts requested the contested case the last time we were before you, or 2 times ago. The last time we were before you, we at DAR recommended denying that petition based on procedural defects with that petition. The board agreed with us and denied the petition. The Alberts then appealed that decision to the circuit court, and the judge has remanded that back to the board and ordered us to conduct a contested case hearing. So while we are doing that, while we must do that, we would also like to take that opportunity to add 2 parties into this contested case who are in the original action. So that was Mr. Jim Jones and Noelani Yacht Charters. This would be done pursuant to Hawaii Administrative Rules 13-1-31A, which states, without a hearing, an applicant or an alleged violator shall be a party. And since both Mr. Jones and Noelani Yacht Charters were alleged violators, we feel it's appropriate to add them at this time. And that's pretty much it. That's all we have. I would like to say, though, we didn't receive any testimony on this, or at least I didn't. If there's anyone who will testify that maybe one of the parties shouldn't be added, we would still recommend adding them and let the hearing officer make that determination later, whether they should be dismissed or not.
Very good. Thank you so
I'll be
very
here
much.
for any questions.
Yeah, board members, do you have any questions of staff? Yes.
I don't have any questions and it is straightforward. So whenever you're ready, I'll make a motion.
Let me see if there's anybody here for public comment.
Thank you.
Okay, thank you both. Do I have anybody from the public who wants to provide a comment on item F1? Okay, is there anyone on Zoom? Okay, I'll close public comments. Board, did you want to make a motion?
Yes, I'd like to move to accept staff submittal. Thank you.
Second.
Okay, a motion has been moved and seconded to approve staff's recommendation for item F1. All in favor, please say aye. Raise your- Motion passes with 6 votes. Let the record reflect that Riley Smith, Board Member Smith, did have to leave the room. Thank you very much, gentlemen. All right, we are through with the items, with the F items. We will now move on to J. Thank you very much, Kathy.
You're out of the past. You're out of the past.
Laying low.
Staying low. Hi, Megan.
Good afternoon. Good afternoon.
Good afternoon, Chair, Board members, Richard Howard for voting. Item J1 is asking the board to delegate authority to the chairperson to negotiate, approve, execute, manage, and extend the service contract for parking monitoring services with Secure Parking Hawaii LLC at the Alawai Small Boat Harbor.
And I'm, excuse me, losing my voice. Megan Stats, I am the administrator for the Division of Voting, and finally nice to meet the 2 new board members. So thank you very much. So before I get started, I just kind of wanted to make it clear that this submittal does not eliminate or change any of the free recreational parking stalls. This agenda item is in response to the board's prior request for more information regarding parking enforcement at the Alawai Small Boat Harbor. The matter of parking enforcement has come before the board on numerous occasions. At the December 7th, 2023 board meeting, upon issuance of a parking concession contract to Secure Parking, the board requested that voting work with Secure Parking on the license plate reader technology to address user complaints. So staff believes that the proposal here will address the most prevalent concerns, including immediate towing for parking violations and the improper use of recreational parking stalls by non-recreational users. So the board previously delegated authority to the chair to negotiate, approve, execute, manage, and extend DOBOR's service contracts. Staff recognizes that this proposal here is different from a typical service contract, such as refuse disposal, electrical plumbing. So this matter is being brought as an action item rather than an informational briefing. So just to give a little bit of background, there are approximately 900 parking stalls at the Alawai Small Boat Harbor, comprised of approximately 300 recreational stalls, which are free and limited to 6 hours per day. The remaining 600 stalls are a mix of paid and permit parking. So staff has reviewed, we have reviewed the public testimony. We just want to address some of the concerns raised, as well as correct some of the inaccurate statements that have been made in the public testimony. I think there's been some concerns about issuing citations rather than towing. So as discussed in the submittal and on previous prior occasions before the board, there is currently no legal authority for DOBOR staff, boating staff, or Secure Parking, its concessionaire, to issue parking citations. While DoCare has authority to cite, it is not the best use of their limited staff and specialized training to take officers away from natural resource protection to write parking tickets. There's also been comments made that the board, not the chairperson, should select a vendor, negotiate, and sign the contract. So the original parking concession contract that was issued to Secure Parking remains in place. There's no changes to that. The proposal before the board is a service contract to authorize and add LPR technology as a parking management tool. Therefore, no terms of the original parking concession contract will be modified, and staff believes management of this service contract should be delegated to the chairperson for efficiency, as has been done with all of DOBOR's other services contracts. So some of the testimony inaccurately portrays the LPR technology as facilitating instant tows. This could not be further from the truth. Under the proposed contract, Secure Parking will provide warnings for the first 2 violations and not tow the vehicle on the same day the second warning is given. So parking violations after the second warning will subject the vehicle to tow. This policy will continue as long as the contract is in place. And as well, we do have a post-tow hearing process that will remain in effect to ensure due process rights of anyone that has their vehicle towed. And then lastly, I just wanted to say, there's been other inaccurate statements that boating is not protecting the recreational parking. Part of this services contract will help the concessionaire to address the misuse and abuse of the 6-hour time limit by non-recreational users such as hotel and construction workers who continue to improperly park in this area. This proposal will better ensure that these stalls are available to recreational users as intended. An individual who parks a vehicle in a recreational stall will not be able to simply relocate the vehicle within the recreational lot and reset the time limit, as the license plate reader will still be able to identify the vehicle during the subsequent checks. We have a representative from Secure Parking here to answer any questions regarding the system itself. And I want to thank Chief Radula for taking the time as well, because I know there's been some comments that have been received regarding enforcement and citation. So sorry that was a little bit lengthy, but I just wanted to address some of the testimony that has come in. And we are here to answer any questions you might have.
Thank you, Richard and Megan. Board members, do you have any questions for either Richard or Megan? Okay. I'm going to take public comments at this time.
Or do you want to hear from Secure Parking first? To do the
Oh,
overview?
sure. You want to come on up?
Yeah, is that any questions?
Do you want to add anything to this new feature that is before the board?
Sure. So I'm Jonathan Alexander with Secure Parking. We've been operating at Alawai Boat Harbor for several years now. We've listened to community complaints about instant towing, what the concerns are there. And I think this program that we're proposing addresses a lot of those complaints that have been brought forth in the past. While it may not solve them in the way they would like in some instances, like they're coming out and ticketing vehicles, I do believe that this will make the harbor a much better place for parkers for the recreational stalls. And free up parking for those recreational stalls too. So, thank you for hearing this proposal, and if you have any questions for me.
Any questions for the contractor?
Sure, I have a question. So in our submittal on page 3, actually, it's the page 4, there's mention of software. What kind of software might it be for him or?
Yeah, he's.
What kind of software are we talking about?
So there's software that runs the LPR equipment. That also has to integrate with the current payment systems as well. So there are pay stations on site, plus we offer a QR code payment. So the software that runs the LPR integrates with all these different technologies.
Okay, great, thank you.
Thank you. Thank you very much. Chief, did you want to add anything?
Not just point.
Okay, all right. Okay, let's take public comment. I know I have Kate Thompson and I have Keone Downington. And then I have Candy.
Well, you keep going first.
Keone.
You got it done. You got it.
Come on up, and if you can introduce yourself.
Aloha Friday, everybody.
Yes, aloha.
My name is Candy Sang. I'm a Kapuna. I am a Kama'aina. I live in Honolulu, Hawaii, and my residence is in Hawaii Kai. And I am speaking up because today is Aloha Friday, and every Friday, because I'm a Kapuna, I go to the harbor. You know, I live like a hermit, but I force myself to go out once a week, every Friday, Aloha Friday. And I met this group of wonderful surfers who cannot be here today. And I am representing all the surfers here in Honolulu, Hawaii. And I am speaking for them in behalf of them because they are plumbers, electricians, painters, concrete people that work on your houses. And they are working now and they cannot be here. And Friday, Aloha Friday, is a very special day for them. They're all married with children. And right after work, they pick up their truck, their cars, their vans, they pick up their children after school and they head to the harbor and they park there and take the children surfing. And after surfing for a few hours, they're all hungry and tired. And, you know, we all chipped in and bring food and we barbecue. And anybody who walked by from England, from Poland, from mainland, tourists, they welcome them and give them food and drinks. And these are the surfers. And they are the ambassador of the state of Hawaii. They represent Hawaii. They're local people that live here, they're Kama'ainas, and they cannot the surfboard to the buses to take public parking. They have to have a car. They have to have a truck to take the surfboard. I do paddleboard. And I think that instead of having tow trucks going around with flashing lights, I see that, harassing the local people, you know, and having all this fancy, expensive equipment to take license plate and towing their cars. I mean, these are the people that serve the
So Candy, I'm going
community.
to ask you to summarize.
I think that the city and county, the board here, the chairman and the members should allow more parking for the local residents instead of using a tow truck and harass the local people that lived here. And they are the ambassadors of the state of Hawaii. They represent the people here to spread the aloha spirit.
Thank you so much.
Those are my thoughts as a resident, as a kapuna that lived here for many, many years.
You know, Candy, I apologize, and I do not mean to offend you. But, and I know Keone, Kaiwi's down there. Kupuna. A kapuna is a spoon, and I know you're not a spoon. kupuna,
Kupuna.
if you don't mind.
Thank you for
Kupuna.
correcting us. Thank you.
You were not the only one, that's why. It's a little pet peeve of mine. Yes.
Thank you.
You're a kupuna. You are a kupuna indeed. Thank you so much, Candy.
Aloha, my name is
Aloha.
Kate Thompson. Thank you, board members. Welcome new board members. Unfortunately, I've been a regular here about secure parking contract and have been a part of filing contested case hearings before because I'm very concerned about what I see as a loophole in enforcement that in 2022, Suzanne Case told the legislature, which I think they still believe, that Doe Care gives the parking tickets, which they're allowed to do, and they gave 4 parking tickets last year, 2024, and 4 in 2023. And for Maui, as you see in my testimony, they gave a few more. But the problem is that this enforcement delegation of the work was just dropped. And what's happened is what has replaced it is that secure parking is allowed to give the meter information via like a tablet that which vehicles have expired. We have asked for analytics, like how much time is there between expired meter and tow. There's also the late night parking, which we have tried to, I have it here. So 4 years ago, we made a 200-person petition asking for ground signage that never happened. We came up with sample warnings. We asked to have this sign attached to the current sign, which is misleading people. A lot of the signs in the harbor are made by the tow truck people, so they have to have a two-inch thing, but this 2 inches that's really skinny and you can't tell what's going on, and the signs are too similar in certain areas between the boater parking. So people can actually pay and get towed there because they're parking in a boater parking. We've also been trying to save the surf wreck parking. And although they constantly say they're not threatening it, they're constantly threatening. That happened in December, but November 2 years ago, which the board stopped. Thank you. So a warning is okay, but the bottom line is that nobody does this. You have Act 163 to make a chance to do a $20 ticket or a $35 ticket. And one thing I want to add is with electronics, we could possibly work with Doe Care, which are the legal people allowed to give tickets. Maybe, at 12 noon and at 4 p.m., they review all the tickets that Secure Parking has found via the new cameras and they approve them all. And then the people get the notifications in the mail or on their car. But Secure Parking is doing remedies like returning people's cars and giving them money, and the AG never sees these things. So there's a lot of problems going on. And if you decide to vote yes on this, I will be filing a contested case hearing because I think the AG needs to know 2,500 people were towed each year. That's just shameful. This is hardship for local families and you can do something about it. Please stay involved. Please ask for some of the things we ask for, Zoom meetings and things. And a real review from the AG. Is this really legal? Is this okay to do this to people? Thank you.
Thank you. Keone?
1 minute.
Hey, you know how hard it is to plan 2 minutes? At least when I was, it was 3. We felt compassion. Good afternoon, board.
Good afternoon.
I'm gonna use 30 seconds on subject matter. To delegate authority to chairperson, negotiate, approve, execute, and extend service contract. Adding the camera system is not extending anything. It's something brand new that I believe should have been added in the subject and not put in details later on for you to read about. My next 30. All construction projects in the vicinity have to go through DPP. Okay, so I'm trying to find a solution. How can we work with DPP to know what contracts are going through? How can we then educate the contractors, the hotels, that parking in a recreational parking is not for non-recreational parkers. And this is where the abuse has come because we haven't done anything in the past. So it's only growing bigger. Cameras. You want to spend $180,000 a year on cameras. We can hire a door care officer to give tickets. A lot cheaper than $180,000 on a camera system that they may have the violator towed, as the submittal says. Back to solutions. We have the honeybee lot. I'm sure you folks are gonna be doing something sooner or later, but that could have been used for parking. We could have negotiated with the hotels or construction to use a lot, because most of the time, this construction is limited to time because they're gonna use off time to do it. Problem is, when you take the summer parking and you shove all the non-recreational users in the summer, that's the biggest problem. But I think, you know, work with HTA, work with Waikiki Beach Improvement Association, right? Work with the hotels. Let's find the solution because it's there. But to say we can't do it because we don't have enough people, I'm just showing if we're willing to throw away $180,000, we can definitely hire people within our system now to do the ticketing, and we'll probably make money off of the ticketing.
Thank you.
I appreciate you being here all morning.
And just one other piece I want to
Hey,
say,
you got 15,
less than 10 seconds, just quick. Secure parking was supposed to monitor this parking lot. And they haven't. It was a part of their agreement. Thank you.
Thank you very much, Karen. Chief. Okay, sorry, let's, Maggie, you're on Zoom. Go ahead and unmute yourself.
I know she's in the room. I could call her.
Oh, here she is.
Oh, there she.
I think she's unmuting herself.
Hello?
Yes, go ahead. We can hear you.
Hello? Can you hear me?
Hear you, yes. Go ahead, Maggie, because we can hear
Hello?
you.
I'm sorry, I can't hear you.
Well, go ahead. We can hear you.
Oh, okay, great. Hello, everyone. Thank you so much for letting me speak, and thank you for your diligence in keeping the harbors a safe and accessible area for people in Hawaii and also people who are outside of Hawaii. I'm a frequent visitor. My name is Captain Maggie Hallahan. I use the harbors. And I'm very concerned about having decisions made about the harbors in a direct, from a director's point of view, and not being brought to the members of BLNR for review and for public testimony. I know that there can be a lot of decisions made, high-tech decisions with surveillance or with cars with cameras in them. And I think that all this should be spoken in a community area space like what you offer now with the board members. And so I just really urge you, I wrote a testimony that I'd like you to read. And I think that transparency and accountability is very important. And that's what these member meetings are offering to everyone is that it gets recorded and noted. And we appreciate having that, being a public member. Thank you so much for your great work in keeping up the harbors. And hopefully we can start giving tickets instead of going straight to towing. That would be a wonderful solution so we don't see people crying on the side of the road because their cars were towed just after they went swimming. So thank you so much.
Thank you very much, Maggie, and I appreciate you following the time limit. So is there anybody else on Zoom, Ross? No. So I'm Chief, did you want to make any comments? Your division has been referenced several times. Give you a chance.
Thank you, Chair. Good afternoon, board members. Jason Redula, I'm the Enforcement Chief for the Division of Conservation and Resources Enforcement. So I'll just say that with this particular submittal, we do support what DOBOR is trying to do here. Surely parking at the Alawai Small Boat Harbor has been a problem for a very long time, especially in the area of the helipad lot, which is the recreational area that a lot of the beach-going public and the surfers and whatnot use. We do recognize that parking at Alawai Small Boat Harbor continues to be an issue, especially on Friday nights when we have the fireworks shoot. But clearly on the weekends and in times where we have the canoe regattas going on, it is a problem. DoCare officers have to perform the law enforcement duties for the broad range of functions and responsibilities that this department has. And so surely we cannot be at Alawai Small Boat Harbor as much as we would like to be. And so there needs to be some kind of parking management in some form. And we do believe that what DOBOR is trying to do here does provide a way to manage parking and enforce the parking rules at Alawai Small Boat Harbor in lieu of having DoCare officers there, because we just can't be everywhere we're needed all the time. Without some kind of tool in use to manage parking, it's going to be chaos down there. It just is. Alawai Small Boat Harbor is one of the only live-in small boat harbors in the state. It is also smack dab in the middle of our resort location, and it's in high demand pretty much 24/7, including late at night, particularly on the weekends and on holidays. And so we do need to have some kind of management tool for parking. And this idea with secure parking and license plate recognition software would supplement DoCare's law enforcement ability to enforce parking at Alawai. Thank you.
Chief, how many DoCare officers do you have statewide?
Okay, so right now we have somewhere in the area of about 130 statewide. However, as with any organization, we are experiencing attrition, particularly here on the island of Oahu, and particularly in what we call Oahu's District 1, which is Metropolitan Honolulu. So at any one time, we may have only 2 or 3 officers working in District 1 that's responsible for Alawai Small Boat Harbor. And that's everything from Mauka to Makai, 3 miles out, from Hickam Air Force Base up to Red Hill, and then eastward to Makupu Point, and every place in between. And so you can kind of see it's a very broad area. And with all of the different functions that we have to perform, it's unfortunate we can't be all places at all times. And so, particularly places like the Alawai do suffer at times because we just can't be there.
Okay, thank you very much, Chief. All right, I think seeing no other public comments, I'm going to close public comments. Board members, do I have a motion or do I have a discussion?
Chair, I move to approve the recommendation.
Second. Motion has been moved and seconded to approve staff's recommendation on item J1. All in favor, please say aye or raise your hand. Okay, so 1, 2. She wanted to testify. No, she's already testified, so. I've closed.
Do something after that, I'm sorry.
Okay, so let's do it. Ross, can you do a roll call vote?
No.
Yes.
Is Sarah Montezuma?
Yes.
For y'all.
Aye.
Chair Shannon.
Aye.
And then.
Aye.
Motion passes with 1, 2, 3, 4, 5 votes. 1, 2, 3, 4, 5 votes and 1 no. Okay, thank you very much. The motion passes.
My name is Kate Thompson. I am going to file a contested case hearing against this decision. And my rationale, just very briefly, less than 1 minute, is that when DLNR Dover brought to the legislature that they wanted to do their own concessions, City and County, Andrew Kawana said, no way, it should be under normal procurement, chapter 102, 103. So that was rejected and there was no cut and they stopped gut and replace. So they instead reworded Act 163 and got Billboard DLNR under Act 163. Then this thing was at that same time in 2022, Chair Case said that doe care officers should be the only officers giving tickets in the state harbors. But they hadn't been assigned for many years to
So
give
Kate,
tickets.
I'm
Okay,
gonna ask-
so anyway, I'm just saying that I will be filing a contested case hearing, and I really hope you'll entertain this with the AG.
Okay, thank you very much. All right, we'll move on to item F1. J2, sorry. Somebody. Not quite, not quite.
Sorry?
We got this.
Yes, that's what I have. Okay, item J2 is the mutual cancellation of revocable permit number 51 issued to North Shore Canoe Club at the Haleiwa Small Boat Harbor. The canoe club was storing a canoe trailer on property and at a minimum rent of $40 a month. They decided to cancel. They provided staff with the required 5-day notice to cancel, and so we would like to cancel the permit by the end of the month.
And you're also requesting.
I'm sorry, we're also requesting waiver of the phase 1.
Okay. Board members, you have any questions of Richard? Is there anybody in the boardroom who wants to make a comment on J2? Is there anyone on Zoom, Ross?
No.
Okay, I'm going to close public comments. Board members, do I have a motion for item J2?
Chair, I move to approve staff's recommendation.
The motion has been moved and seconded to approve item J2 as submitted by staff. All in favor, please say aye or raise your hand. Motion passes with 6 votes. Thank you very much. Thank you very much, Dobar. I'm now going to take item K1 was with. Can you see where is Michael for item J2? Thank you. Megan, could you ask Michael?
Yes,
Item J2, thank you. K2. So this is the one we did, a temporary restraining order has been filed, but as of 1 o'clock this afternoon, we've not received word whether the court has granted the TRO. So,
It has not.
okay, it
I
is not
checked the docket.
granted. Okay, thank you. So no TRO prevents us from taking action, but we'll wait for staff. And I don't, do we have anybody, do we have the landowner on Zoom, Ross?
No.
Okay. We'll just wait for staff. Oh, hey, Trevor. K2, okay?
That was unexpectedly fast.
I know, it moved quite along.
We were in a sleeping ground, no lie.
Love that happening. Good afternoon.
Good afternoon.
Chair, board members, Michael Kane, Administrator, Office of Conservation and Coastal Lands. We are here today to present a violation case. Item K2. Excuse me while I organize my papers. And this is our request for administrative fines against Mr. and Mrs. Robin and Amy Glass for what we allege are modifications to a single-family residence without a permit and erosion control and landscaping work within the conservation district without a permit. You have a lot of information before you. First up, I know that the Glasses were aware of this hearing. I do not know if they're present.
They're not. We just
Okay.
checked. They were not on Zoom, but they are aware of the meeting today.
Absolutely, and we have evidence. So
You'll see a lot of correspondence back and forth. I'll try to give you the 5-minute version.
Less than 5-minute version.
Okay, well, we have so much time now. Okay, so the 2-minute version. Our location is Tantalus, which is the hills above Honolulu, developed area. Residences are allowed in the conservation district. Most of the residences on Tantalus are non-conforming uses, meaning they were built before 1964 and their inclusion in the conservation district. And the residence in question was originally a non-conforming use. It's a question whether it is now. In July 2022, we were contacted by the landowner regarding erosion and runoff on his property, and made a request to do some erosion control work. We had a year's worth of correspondences with him. At one point, we let him know that it would require a board permit and environmental assessment to do the work that he was proposing. However, over the course of the year, we realized that he had actually begun doing the work, that he had violations from the city and county for doing unauthorized grading work, and that there had been modifications to the residence without a permit. So we issued a notice of alleged violation in June 2023, focusing on the modifications to the residence and the erosion control work. The report outlines the erosion/landscaping work that was done. I want to work the math out with you on the residence. So maximum developed area for a residence on this parcel would be 3,278 square feet, or 25% of the lot size.
And that's provided by statute.
That,
by
correct.
administrative rules.
So the non-conforming structure, what we have records of, is 1,154 square feet. So that's your baseline. At some point, the house, the bottom floor was enclosed, adding about 744 square feet, bringing the total to 1,898 square feet. So we're still under the MDA. We believe that work occurred over 25 years ago, but we have records that show that this was also disclosed to the Glasses when they bought it, that the residents did not match the tax records. The work, some of the work that they conducted was to build an additional 1,884 square feet worth of patio deck and walkways around the residence. That would bring it up 500 feet approximately over what's permissible. So that first work that occurred over 25 years ago, the landowner then could have applied for a board permit. We considered a major alteration. We would have presented to the board for approval or denial. But there is precedence for the board approving that work. The second work that was that they had initiated for the walk around area would have brought it over the maximum developed area, and we would have not accepted a permit for processing and not brought it to the board. So I think Trevor did a good job of outlining our logic behind the fines. I just want to bring one to your attention for the board's consideration. Well, two. We're asking for an after the fact permit for the erosion control work, just because we want to make sure it meets safety standards. For the additions to the residence, condition 5, the recommendation is that the unauthorized modifications would return it to its original 1,154 square feet. We based that on the Silva decision that said you did work without a permit, you need to remove it. The board does have the option since to ask for a to replace that with the condition that they submit it and secure an after the fact permit for the additions. Realizing the board can't really go harder than what we recommend, so we're recommending the hardest. But I want to acknowledge that you do have that.
Is that the 34,000?
No, so this would be, it's currently 1898. Condition 5 would bring it to 1154.
Okay,
But the alternative would be for the board to entertain allowing them to apply for an after the fact for the additional 7, basically for enclosing the bottom floor. We're not asking that you entertain the walk around that would bring it above.
so what are the proposed fines that you're recommending?
Total is $34,000.
That's what I thought.
So it's not, we're not going for record-breaking fines here. But they are significant.
And why not? I mean, if we go all the way back to
Yeah.
whatever,
Mhm.
should there not be a dwelling on conservation land?
Oh, no. Oh, no to the question.
No, no.
So the original conservation rules allowed for hotels and golf courses and dude ranches and resorts. So it really wasn't until the new constitution that enshrined like public trust values within the conservation district. So there was I wasn't around then, but some of those land uses did carry over. They couldn't, we were able to take out golf courses and dude ranches, but single family residences in some subzones were carried over. So it's the idea of conservation has evolved since statehood. Yeah, that's the logic I can give you. So regardless of my feelings about it, it is the law.
Thank you, Mike.
Any other questions,
I have a
Karen?
question. So what about the patio and the walkway?
So they started grading on it, but they haven't started building it. They haven't started putting in the wood.
Do you even
So
have a grading permit?
no.
Oh, God.
And they do have county violations.
Did they
And
pay the county violations? or
my
do you know that?
assumption is that no,
Okay.
do we know?
Can we just have this recorded at BOC?
Um,
Staff planner Trevor Fitzpatrick wrote the report. They were issued notices of violations from the county, and right now I think they were under appeal with the county, and now they're in court with the county over those.
Oh, yeah.
In the recommendations, guys, there's a coupling of the future owner to the property. Is it your sense that they're wanting to flip it? Is that why you make reference to future owner?
I don't have evidence of that,
Okay.
but it's the fact that it has occurred in the past.
Yeah, you
that
just
I
wanna
think that's
cover
gonna be
our
a
bases.
standard recommendation
Okay.
moving forward.
Is there a clause in our rules of conveying a non-conforming structure or the inability to convey a non-conforming structure?
So not entirely sure what that means, but my argument would be if the additions, the 744 square foot addition is allowed to remain, I don't know if it would qualify as non-conforming because it's a major modification.
But I think to your question, Kaivi, zoning runs with the land.
Yeah.
So,
Yeah.
so a non-conforming use would run with the land so long as they kept the house. The house gets demolished like a seawall.
Yeah.
That's they don't get to rebuild.
Or they could rebuild according to modern,
Yeah. They have to.
they have to go through,
Current code, yeah.
current code, thank you.
Yeah.
So can I ask a point of clarification? This enforcement case that we're talking about
Mhm.
on this agenda item, is that enforcement case filed anywhere so that if somebody does a Bureau of Conveyances search that it shows up as an encumbrance or cloud on title?
I don't know about an encumbrance or cloud, but one of the recommendations and standard practice under current rules is that whatever your decision is, that will get recorded, or the landowner will need to record that at the BOC, which then hopefully will turn up in a title report if it was sold in the future.
Yeah, and that's,
I understand what you're saying, that the permit issue would show up in any realtor with experience and everything would pick that up and say that this structure does not have approved permits for the structure that exists on the property. But I just was wondering if our enforcement action would then pop up So, maybe I should back up. Are you saying that right now, if somebody did some sort of search, that the enforcement action would not pop up?
I believe that's the case, but our recommendation, condition number 13, is the board's decision be recorded.
Okay, thank you.
I guess a point of context for the new board members is if this were an application for a resident in the conservation district, one of the standard conditions is that that permit and those conditions get recorded at the BOC by the landowner. So that information is on file for something like you said, or asking about.
So I think like enforcement action, only when it's been adjudicated and we've given the homeowner an opportunity to, then can we record it? I don't think we can just record a violation.
That's my
But
understanding.
there's also, last year, didn't we get the real, there was a law that was
Yes,
passed,
so there
right?
was an
Yeah.
amendment, there has been a real estate disclosure law, an amendment to that which requires in real estate transactions that notices of violations and any pending fines need to be disclosed
Yeah.
with that.
Is that it? Is that part of a standard real estate contract?
That
I think it is. It's chapter 508D.
and that's this, yeah.
Yeah.
Just for my clarification, if there is like an ongoing contested case hearing or a lawsuit, the practice over at our office is to file a list pendants, which would show up on a title report.
Okay.
Okay.
The Punaluu case, the one that we recently, that was the way we were able to get the new homeowner liable or responsible is because when he bought the land, when he bought the property in Punaluu, the violation and the decision of the contested case hearing, wasn't that also placed on the deed so that the new owner had full knowledge and bought knowing that there's an outstanding, or at least what the violation was, and that's how we could get the,
Correct.
right? And they
Should
have
I
to pay for that.
Fill
right?
in the rest of the board what we're talking about is
Yeah.
correct, okay?
Yeah, I think, okay. Yeah, so laws have been changed because in the past, we haven't recorded those notices or the violations.
So the last question I have is, I see your recommendation number 13. And why are we requiring the Glasses to file something with the Bureau of Conveyances rather than we taking that affirmative step? Because if they don't go ahead and file that, I realize that would be a violation. But then there wouldn't be anything filed with the Bureau of Conveyances.
I think in that case, if I would imagine there'd be other non-compliance issues, which we would then probably bring back to you folks. Right, and ask for further penalties, maybe daily fines. And then at that point, one of the recommendations in here, if there's that much non-compliance, we would ask to turn this over to the attorney generals who would then pursue action probably in court.
Okay.
Yeah, and I think more of it as a matter of policy, rather than putting the burden on us to file, we've been having the landowner, but it does permit us to then, now they're in violation of the order because they haven't filed. But yeah, putting more of that, because of our lack of capacity. Although the
How
bureau
would
is
you
right next door.
characterize how would you characterize our relationship, or shoot, how do I ask this? How do you characterize the Glasses? Is it misinformed, blissfully ignorant, or they know what they're doing and are pushing back? Because I wanna.
I think if you read through the emails, you'll get a sense of, there's some nonlinear thinking
Okay,
there, and I don't want to hypothesize about what.
yeah, I just want to give benefit of the doubt in case, someone's just not aware. But I find that hard to believe.
Yeah.
Yeah, I'd be a little cautious because they filed a lawsuit.
Oh,
So they did file the TRO, so I want to be careful that they may end up being witnesses.
Sorry, I didn't know.
No, it's fine. We didn't disclose out to the board.
Well, I sent that out to all the board members, the TRO.
Oh, okay, sorry, I didn't get that one.
Motion for TRO.
Yeah, the motion.
TRO.
Yeah, well, I don't
motion.
actually have a TRO against me.
Yeah.
They were excited. They thought it was a bad boy. My staff.
Badge of honor.
Like, what did you do?
Ah,
Anyway.
you'll get enough of those that you won't want that.
No,
Okay, any other, is there anyone on Zoom, Ross? I will close public comments. Board members, do I have a motion?
I move to approve staff recommendation.
Do I have a second? A motion has been moved and seconded to approve staff's recommendation on item K2. And let the record reflect that the landowner was notified of the board meeting, the landowner is not present either in the board room or on Zoom. So, and okay, now I'm going to go back to the motion. There's been a motion to accept staff's recommendation on item K2. All in favor, please say aye or raise your hand. Motion passes with 6 votes. Woo!
Okay.
Having no other business before the board, meeting is adjourned at 1:20. That's pretty good. We got